Will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook, Representative Bajani,
Here.
Representative Bowers, Representative Darby,
Here.
Representative Harrison,
Here.
Representative Leach,
Here.
Representative Christina Morales, Representative Schatzline.
Here.
A quorum is present. Real quick, as a reminder to anyone that is present that wishes to testify, if you want to come before the committee, we're going to need you to register at the kiosks that are located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please make sure to communicate with our committee staff and we'll help you out. I do want to also note that we're going to continue to limit testimony to 3 minutes. Doesn't include questions that the members have for the witnesses, but we do deal with a number of topics that can expand quickly in conversation, and so we want to be respectful of everyone's time, and so that way we're able to get to as much as possible. We're going to continue to use that throughout this session. Before we get started, just some notes for everybody. We've had 135 bills referred to this committee already, and we were the first committee to report a bill to calendars. So told you we're going to try to be efficient, mainly because we're going to be very busy, and so we're going to continue to try and keep with that. In keeping with our efficiency, I'm going to go ahead and refer some bills to subcommittee as well. The chair refers the following bills to the subcommittee on criminal procedure: House Bill 762, House Bill 779, House Bill 782, House Bill 908, House Bill 946, House Bill 964, House Bill 1017, House Bill 1104, House Bill 1230, House Bill 1231, House Bill 1232, House Bill 1233, and HJR 53. The chair refers the following bills to the subcommittee on asset forfeiture: House Bill 928 and House Bill 1442. And chair will note that Representative Harrison has joined us. All right. We don't have a substitute for this. There's no substitute. No? Okay. This time, chair lays out House Bill 369 and recognizes Dean Thompson to explain the bill.
Thank you, Mr. Chairman and members. Individuals found in possession of even residues or trace amounts of a controlled substance can be convicted of a state jail felony or sent to a jail or prison. In 2021, on average, Texas spent over $105 million annually to incarcerate people convicted of low-level drug possessions. However, lab tests can be done to prove the presence of drugs and has exonerated people already convicted of drug charges in cases that there were no drugs to begin with. In order for the state and the defense to both test samples of suspected drugs, there must be at least 2/100 of a gram of material. This bill, House Bill 369, would establish 2/100 of a gram as the minimum weight of a controlled substance in penalty group 1 or penalty group 1B, necessary to constitute a state jail felony. This amount would protect due process by allowing both the state and defense to test a suspected controlled substance in a crime lab. Data shows that many jurisdictions in Texas currently do not prosecute trace amounts of drugs and have since been seen that they are not cost efficient for prosecution, as well as the cost of jailing these individuals to go down significantly while experiencing no increase in other crimes. Mr. Chairman, I am available for questions of this committee, and I would like to reserve the right to close.
Okay. We recognize that Vice Chair Cook has joined us. Members, do we have any questions for Dean Thompson on this bill? No? Okay. Then we will proceed to public testimony. recognize that Representative Morales has joined us. Chair calls Lauren Johnson. And Lauren, I know you've done this a couple of times before, but please state your name, whom you represent if someone other than yourself, and your position on the measure.
Got it. My name is Lauren Johnson. Good afternoon. I work for the ACLU of Texas. I'm a policy advocacy strategist there. And we are here to testify in favor of this bill. Just for context, 1 gram of substance is about equal to a sugar packet. So what this bill does is talking about 2/10 of a sugar packet. So very, very little bit of substance. And the other context that I want to create here is that we're talking about people who, generally speaking, have substance use issue or mental health disorder. And we all know that our county jails have become the #1 provider of mental health and treatment. And at that, even at that, they're not equipped or funded to deal with those issues. So I think that this bill would be one step in the right direction. I think we should go a little bit further, but today we're talking about this bill. We're in an arena where most of your counties have court backlogs. So adding controlled substance, less than trace amounts of a controlled substance to your court backlogs is not efficient. It's not efficient at any point in your criminal justice system for your labs to be doing the testing, for the money that we're spending to incarcerate people where they're not getting access to mental health treatments or substance use treatments. And a little bit personally about me is that my last time going to prison was basically for trace amounts. I had been clean for 5 years, had been doing well, had created a family, had bought a house, and had a relapse and wound up back in jail. And the charge was trace amounts, but in Texas, trace amounts is still a felony charge. And the prosecutor on my case decided to send me back to prison because I had already been there once before. And at that point, prison did not give me substance use treatment. It did not give me access to resources, education, vocation. None of those things were given to me during the 7 months that I was taken away from my children. So we paid a lot of money to warehouse me in a facility when what could have been more effective was offering me community alternatives and resources. So all of that is to say, it's an enormous waste of our people and our resources to continue to criminalize this at a felony level. I'm happy to answer questions, but I'm also happy to keep things short.
Lauren, thank you very much, and I appreciate y'all always being willing to bring your personal story and your voice into this. I know that has been, at times can get challenging to wade into those issues again, but grateful for you spending time with us. Members, do you have any questions for Lauren? Yes, Mr. Schatzline.
Thank you, Mr. Chair. Just a question on this one specifically relating to the types of drugs that this is referencing. Does this include drugs like fentanyl, Oxycontin, those type of drugs as well?
So I would have to go back and look at the bill language, but I believe that those are in their own narcotics scheduling category, and that would be outside of this. I would ask Ms. T to confirm that, but that's my belief. Having said that, though, I will say, we've got some bills this session that seek to increase penalties for fentanyl, and I think that the urge to do something is understandable. We're seeing the devastation in our communities, but what we're doing to solve that is we're criminalizing the people that we supposedly want to save. And so while I understand the urge to do something to intervene in our communities, further criminalizing fentanyl is not going to be the solution. Like doing more of the same thing we've done before that hasn't worked isn't effective.
What I'll do for the committee is we'll get the penalty groups to give you an idea of when you see PG1, PG2, or whatever. That way you all have a shorthand way of knowing when you see it in a bill what we're talking about, and we'll get that prepared. I want to say that that's something like that we've done in the past, so we'll get that out to the committee members. That way it's a shorthand.
Thank you, Chairman.
Shorthand way of doing that.
Appreciate it. Thank you.
Mm-hmm. Okay. Is there anyone else who wishes to testify on, for, or against House Bill 369 at this time? If not, the chair recognizes Dean Thompson to close on her bill.
Mr. Chairman, I close, and I want to thank the committee for letting me present this great bill.
Thank you. I know you've been working on this subject matter for quite some time.
I have been.
And there's a lot of history out of Harris County dealing with this bill, so I think it behoove everybody to look into that as well.
Thank you.
Members, if there's no objection, the bill or resolution will be left pending. Is there any objection? The chair hears none, and House Bill 369 is left pending at this time. Chair lays out House Bill 842. Recognizes Representative Patterson. We had a talk about it, Chairman. You think that I would let Patterson go before Tony without talking to her first? Man, I must be dumber than, you must
Have nothing to do with that.
think I'm dumber than I look, I guess. Don't you worry. Well, now you got a lot of pressure on you. Before we do that, before we put that pressure on you, Chair offers up committee substitute to House Bill 842 and recognizes Representative Patterson to explain the bill and the differences in the substitute and the differences with the bill.
Thank you, Mr. Chairman. Chairman Moody, members of the committee, thank you so much for the opportunity to lay out today House Bill 842. And I have one of my local justices of the peace here who's registering in the back hall that's here to testify. He's kind of my expert witness here, but we're excited to have him. Here's the kind of the situation with this bill. So from 2003 to 2019, DPS operated the Driver Responsibility Program. The program would require surcharge fees regarding certain traffic violations. If a driver couldn't pay or keep up with the surcharge fees, their license would get suspended. So this action would create a cycle of drivers getting a suspended license, then driving with the DWLI citation, then getting suspended again, and then the cycle would repeat itself. Thankfully, Texas did away with this program back in 2019, but those affected by it are still paying the consequences. So DPS removed license suspensions from surcharge debts, but the suspension cycle still has people who will not come and plead guilty and pay the necessary fines and fees because it will be suspended again. So basically, there are people not coming to pay their fees because once they pay those fees, then they're suspended another 2 years on top of that. So for those struggling individuals, HB 842 would allow them to get their lives back and out of unnecessary cycle of license suspension that took place under this ineffective program that we've already repealed as a legislature. The bill does not change any local criminal penalties for DWLI citations and only applies to private drivers, so no commercial drivers. And that is we clarified that change in the committee sub. Let's see, skipping ahead. Basically, the changes with the committee sub are clarifying the suspension and extension. If they broke the law, they still have to pay for that crime. Especially if it was a DWI or something like that. Like, we're not wiping away any of those penalties. We're only talking about driving while licensed, DWLI. And then also we clarified that this is not about commercial drivers because that's a federal law issue. And then we also clarified that the Texas Mobility Fund, when these folks come in, they're still going to pay the fee. So there's not a revenue loss there from the Texas Mobility Fund. The fee still gets paid. They just simply don't have that 2-year time frame. Basically, it also only accounts for folks that had this issue before 2019. So in theory, in the future, we'll have fewer and fewer of these cases that need to be resolved. But, these are folks that, had something happen prior to 2019, and they could have a driver's license suspended still, and then, they're moving on down the road. They finally want to get their life back in order. They pay this fine, but then they have another 2-year suspension for something that could have happened 5-6 years ago. So that's what we're trying to clean up here. I'd be happy to take any questions that you have, and then certainly hope to reserve my right to close if that pleases the chairman.
Thank you, Mr. Patterson. I know that Representative Rose has multiple questions on this bill. And even though she's not on the committee, I know I'm going to let her know. You okay with it right now? It only goes if you say so. All right, so I'll look to you. Now, members, do you have any questions for Representative Patterson this time? No? Okay, then we'll proceed to public testimony and reserve your right to close. Chair calls Sarah Mae Jennings.
Thank you, Chair Moody and Criminal Jurisprudence Committee members. My name is Sarah Mae Jennings. I am the Interim Co-Executive Director and Policy Director at the Texas Fair Defense Project. And I'm here to express our strong support for House Bill 842, which is a common sense bill that will improve public safety in Texas by increasing the number of licensed drivers on the road. At TFDP, we represent hundreds of people each year who have fallen into what feels like an inescapable cycle of ticket debt and license suspensions. When people cannot pay their legal debt, they receive an arrest warrant, accumulate additional fees, and lose their driver's license under the OmniBase program. They feel stuck, unable to get a job until they have a valid license, unable to get a valid license until they clear their legal debt, but unable to pay off that legal debt until they get a job. The truth of the matter is, even without a valid license, Texans will continue to drive out of necessity to get themselves and their children to work, to school, to medical appointments, and even to court. Inevitably, they will be ticketed again for driving while license invalid. And a conviction for driving while license invalid carries with it an automatic new suspension on the driver's license. Plus, each additional ticket is an additional hundreds of dollars, and that's before any additional warrant fees, late fees, and so on and so forth. You can imagine how these tickets, suspensions, and legal debts snowball quickly for those Texans who were never in a financial position to pay off that first ticket. Having a valid driver's license makes it significantly more likely for a person to have earnings above the poverty level. Driver's license suspensions for failure to pay erect barriers to Texans finding work and getting to work, leading to unemployment and lost wages. A recent study found that the average earnings loss from a suspended driver's license is about $12,700 per person per year. Limiting extension of driver's license suspension for driving while license invalid convictions will promote public safety by reducing the number of unlicensed drivers on the roads in Texas and would be an important step for equity in Texas. I would also just like to note, I have spoken with Representative Patterson's office that this bill would be even stronger by removing those time restrictions. Although the DRP initially created this backlog, the OmniBase program continues to be a problem for Texans in a very similar way. And I think removing those restrictions would make it so that we don't continue to run into this issue moving forward. Thank you for your time. I'm happy to answer any questions.
Thank you very much. Members, do we have any questions? All right,
Thank you.
Chair will call Judge James DiPiazza.
Chair Moody and members of the committee, thank you for the opportunity to come and present this to you. I want to start by sharing with you 4 specific scenarios regarding the reason why I approached Representative Patterson to see about taking care of this issue. 3 of them came from individuals who came to me for an occupational driver's license, and 1 is from an individual who had a driving license invalid citation.
Judge, I'm sorry, before you proceed, you're here to testify for, on, or against the measure?
For
Thank you.
I'm new to this.
And you're representing yourself here today?
Yes, sir.
Thank you.
The first case was a 31-year-old whose eligibility to drive was suspended in 2016 for not paying her surcharges on a no driver's license conviction when she was 25 years old. In 2018, she received 2 traffic-related citations, which she did not take care of until July of 2021. In August 21, she received a notice from DPS of a 1-year department suspension because the offenses were committed when she was in default on her surcharge payments that stemmed prior to the repeal of the driver's responsibility program. The second one is a 28-year-old whose eligibility was revoked because of unpaid surcharges beginning in January 2015 from a no driver's license citation she received in 2014 when she was 20 years old. The lift date of her suspension is in conjunction with the repeal of the driver's responsibility program in 2019. She received a DWLI citation in 2017. 5 years later, she pleads and pays a citation to recall and satisfy an outstanding warrant. The result is a mandatory 2-year suspension of her license, where she stated this in her application for her ODL. Traffic violations since 2010, such as speeding, ran stop sign, or my child wasn't wearing a seatbelt. I just never had the funds to pay off the tickets and left it at that. I'm trying to be a law-abiding citizen by trying to do the right thing, which is why I'm requesting an occupational license to start paying off the tickets that are still outstanding. This young lady is a single mother of 3 who is living at home with her mother after leaving an abusive relationship and trying to get a job and make a life for herself and her children. The third case is a 37-year-old whose only suspensions were due to a non-payment of surcharges. She received a DWI citation in 2015, which she did not take care of until 2021, where she finds out that she has an outstanding warrant. So she comes in, she pays the fee for the citation, the warrant fee to get the warrant recalled and satisfy the citation. She receives a mandatory suspension for 2 years for doing this. The final scenario is a young man of 20 when he received his driving with license invalid citation because his license was suspended due to an outstanding surcharges. He is now 33 years old and going through a background check for a new job. He is told that he has an outstanding warrant in my court and he has to be taken care of before he can get his job and be hired. He comes to the court, wants to pay the warrant to get it recalled. Does that mean I need to stop?
About 30 seconds,
Okay.
Judge.
But to get it recalled to settle the case, because I have a practice that I do not allow a plea without them reading about the potential of a driver's license being revoked, he opts to make a plea in front of me, which I go ahead and take care of as I do with all of them. I put them on deferred, get them to pay their court costs, their warrant fees, and a small deferred fee if they show me that they have a valid license. At that point in time, then I will dismiss the case, so it will not go to DPS for the license suspension. As a judicial officer, I believe it is my responsibility to uphold the law. While all 4 individuals and the many just like them are guilty for what they did, I truly believe this is one of those times that the 3 branches of government can come to an agreement that the increased punishment of a driver's license suspension for these types of cases goes beyond justice and rightness. My hope and prayer is that you agree to advance this legislation and that the full House, Senate, and Governor Abbott deem it just and equitable to make a law. I thank you for your time, and I'm happy to answer any questions.
Judge, thank you very much. I appreciate you taking the time to be here and also showing us the nuts and bolts of what you're dealing with. Gives us a good understanding of the situation that you're facing. So, members, do we have any questions for the judge while he's here? No? Thank you, Judge. Appreciate
Thank
it.
you.
Is there anyone else wishing to testify on, for, or against House Bill 842? Chair sees none. Recognize Representative Patterson to close on the measure.
Thank you, Mr. Chairman, and committee members for allowing me to come here today. I think you can see that at the end of the day, what we're trying to do with this bill is just help people rectify their situation and get on with their lives and not have this unnecessary burden follow them around for an extended period of time. So with that, I'd close unless you have any other questions.
Thank you, Mr. Patterson. Do you have any questions? Members? No? Thank you.
Thank you.
At this time, Chair withdraws the committee substitute to House Bill 842. And if there is no objection, House Bill 842 will be left pending. Is there any objection? Chair hears none. House Bill 842 is left pending at this time. We don't have a sub on this. There's no sub. This time, Chair lays out House Bill 727 and recognizes Representative Rose to explain her bill.
Thank you, Mr. Chairman. I appreciate you allowing me to take a seat up here on the dais while I lay out House Bill 727.
Yes, ma'am.
Thank you. Members, this is the 3rd time that we've had this particular bill, and we've been able to pass it out of the House 2 times. Well, I think this is the 4th time, but twice we've been able to pass it out of the House. And we were not able to get a hearing in the Senate, but we're hoping that because we're getting an earlier start, that we will be able to get it through the Senate. And so, members, today, individuals with severe mental illness can be sentenced to death. Current protections for defendants are not enough. They fail to protect the right of individuals with severe mental illness at the time of offense. The U.S. Supreme Court has ruled that our system's current protections for individuals facing capital punishment are fundamentally founded on the idea that individuals who fail to understand their actions or why they are being punished are not fit to be sentenced to death by our government. Yet, protections that currently exist for individuals living with severe mental illness do not include exemption from being sentenced to death. A prime example of our current system is an inmate who's actually scheduled to be executed on April the 5th by the name of Andre Thomas, and I believe my witnesses will go a little bit more in detail about Mr. Thomas. But Mr. Thomas, and again, I just want to make this statement. When we talk about eliminating or exempting the death penalty, we're still saying that people will be punished, but a person who is severely mentally ill or someone who's born with a mental illness should not be sentenced to death. So I don't want to ever make it seem that we're trying to ignore the crimes that were committed. We're just saying because a person has a severe mental illness, that that person should not be sentenced to death with the illness that they were born with. Okay? So Mr. Thomas has been considered the most severely mentally ill person ever to be in the Texas Department of Criminal Justice. While in prison, Mr. Thomas actually gouged both of his eyes out and swallowed them while he was in jail. Even when he was declared incompetent to stand trial, but 40 days later, he was found competent to stand trial for capital murder. The United States Court of Appeals for the Fifth Circuit held Mr. Thomas, who continues to hear voices despite the heavy antipsychotic medications he takes, that he's competent to be executed, and the United States Supreme Court declined to review his case. The jury that sentenced Mr. Thomas to death never heard anything about his mental illness. When House Bill 727 is enacted, the defendant can ask the jury to determine whether or not the defendant has a severe mental illness at the time of the crime. House Bill 727 creates a way for the courts to assess on a case-by-case basis whether the defendant has a severe mental illness. It places a burden on the defendant, meaning the defendant must show by clear and convincing evidence that he or she had a mental illness at the time of the offense. The exemption created under this bill would apply to persons who have 3 diagnoses: schizophrenia, schizoaffective disorder, and or bipolar disorder. And the defendant must show proof they had active psychotic symptoms at the time of the offense. The bill holds individuals with severe mental illness accountable. Again, the defendant does not allow offenders to walk away free by sentencing them to life in prison. Members, in Ohio, they enacted a severe mental illness bill in 2020. The legislature banned the use of the death penalty for persons diagnosed with schizoaffective disorder, bipolar disorder, and delusional disorder. It is past time for Texas to do the same. Thank you, Mr. Chairman and members, and I reserve the right to close and will answer any questions you may have.
Thank you, Representative Rose. Members, do you have any questions of Representative Rose at this time? If not, we'll move to public testimony. And Chair calls Dr. Kimberly Harrison. And Doctor, if you could state your name, whom you represent, if it's someone other than yourself, and then your position on the measure.
Thank you, Chair Moody and members of the Criminal Jurisprudence Committee. My name is Dr. Kimberly Harrison, and I am here on behalf of myself in support of House Bill 727. I am a clinical psychologist and board certified in forensic psychology. I operate a private practice based in Austin that involves conducting psychological evaluations of individuals involved in criminal court proceedings, including their mental state at the time of the offense. I believe that there are many reasons individuals with severe mental illness at the time of the offense should be exempt from the death penalty, such as the fact that their impairments in reality perception, thinking, reasoning, and judgment affect their behavior and culpability, the need for parity with other classes of death penalty exempt individuals, such as juveniles and people with intellectual disabilities, the financial costs of mental health evaluations and court hearings to determine if a mentally ill inmate is competent to be executed, and the seemingly endless legal wrangling that leaves everyone involved, including victims' families, waiting for decades for the execution to be carried out. Qualified forensic psychologists are able to conduct valid and reliable evaluations of defendants' mental state at the time of the offense. We have well-validated tests and procedures to determine the validity of reported symptoms and to detect feigning of mental illness. Representative Rose already mentioned the case of Andre Thomas. I just wanted to highlight another case where this bill would apply. Many of you are likely familiar with the case of Scott Panetti. In 1992, in Fredericksburg, Mr. Panetti killed his mother-in-law and father-in-law. By that point, he already had a lengthy and documented history of psychosis and had been psychiatrically hospitalized at least 12 times prior to the murders. At the time of his trial in 1995, he had stopped taking psychiatric medications and was allowed to represent himself. He attempted to subpoena the Pope, John F. Kennedy, and Jesus as witnesses in his defense. He pleaded not guilty by reason of insanity, but was convicted and sentenced to death. Since his conviction, Panetti's mental illness has been the basis of multiple appeals, both to state and federal courts. When his execution date was set in 2004, he asserted he was incompetent to be executed, and the case eventually made its way to the U.S. Supreme Court. In 2008, the Supreme Court ruled that the Texas courts did not comply with the minimum standards for determining competence to be executed. After 10 more years of appeals and hearings, his execution date was set in 2014. The execution was again stayed by the Fifth Circuit. In 2017, he was granted another competency evaluation, and a hearing was finally held in October 2022. While the opposing experts both agree he suffers from severe mental illness, they disagree on whether he is competent to be executed. The judge has not yet ruled. So since the murders in 1992, Panetti's case has now dragged on for 31 years. Passing House Bill 727 would mean that defendants who are determined to have a severe mental illness at the time of the alleged offense would be exempt from the death penalty, and if convicted of capital murder, would be sentenced to life without parole. The decades-long delays, financial burden to the state for court hearings and mental health evaluations, and the lack of closure for victims' families would be remedied.
Dr. Harrison, thank you so much for your testimony. Members, did we have? Sure, Representative Bojani.
So what's the difference between what the bill that Ms. T filed last time, she laid out last week?
Oh, this is a question for me.
Right, yeah.
Oh, okay.
Yeah, if that's okay.
You're not recognized for such purposes. So two different, so you're talking about two different populations, right? Ms. Dean Thompson's bill that we voted on last week has to do with individuals with an intellectual or developmental disability. And this bill specifically is the population with specific illnesses categorized as severe mental illness. And so two different populations. Is what you're talking about. Same, I believe, I don't want to speak too far as go, I think same pretrial structure for determining, or how do we land on that, Tony? Is that how it is?
I don't know how Ms. T's.
Well,
And you can
Okay.
weigh in too. You're the expert.
So the Supreme Court has said that individuals with intellectual disability cannot be executed. And so I believe the bill that you're referencing is seeking to establish the procedures in Texas that Texas would use to determine if a defendant has intellectual disability or not.
Procedure.
Okay. So the Supreme Court has not made a categorical exemption for individuals with severe mental illness. They have said that you can't execute the insane, that you have to be competent in order to be executed. And so this bill would sort of prevent all that wrangling at that end of the process by just taking the death penalty off the table at the beginning of the trial process.
So both pretrial. This one is ahead of the case law, I'd say, whereas you've got a long history of case law on IDD. Any other questions, members? Nope. Thank you so much.
Thank you.
Chair calls Susie Bell Gossley. Welcome.
Thank you.
And if you could state your name,
Yes,
whom you represent, if it's someone other than yourself, and then your position on the bill.
thank you. Chairman Hoodie and committee members, I'm Susie Bell Gossley. I'm testifying for myself in support of HB 727. I really appreciate your having a hearing and making the democratic process work and hearing from the public. I support 727 relating to the applicability of the death penalty to a capital offense committed by a person with severe mental illness. The bill has listed the types of severe mental illness where the bill applies, so it's very clear. Ohio and Kentucky have already prohibited killing people with severe mental health illness, so the passage of this bill does not set a precedent. Florida is also considering a bill with this newest emergence of legislation to prevent executing a person with severe mental illness. It's time that Texas passes this bill. The United States is the only country in this hemisphere that executes people. Texas executes more people than any other state in the nation. Andrea Yates is an example of a psychotic killer. She drowned 5 children in the bathtub. At first, she was deemed sane and sentenced to life in prison. But then that verdict was reversed, and she was recognized as being insane and sent to a psychiatric hospital. Andrea Yates is an example of why Texas should not have the death penalty, because it doesn't work. Thank you.
Thank you very much. Members, did we have any questions? Nope. Chair calls Jenny Andrews. Thank you so much. And I'll continue to repeat myself. Just state your name, whom you represent, if someone other than yourself, and then your position on the measure. Thank you.
Good afternoon, Chair Moody and members of the committee. My name is Jenny Andrews. I'm a policy analyst for the Texas Catholic Conference of Bishops, and I'm here to testify in support of HB 727. The bishops support criminal justice reform that provides compassionate treatment of prisoners, responds to the needs of victims of crime, and encourages rehabilitation and forgiveness of those re-entering society. We oppose the imposition of the death penalty, and we intervene on behalf of condemned offenders to plead for mercy. This bill prohibits the sentence of death on a defendant who, at the time of the commission of a capital offense, was a person with severe mental illness. According to the Texas Alliance for Severe Mental Illness Exemption, approximately 1.1 million adults are living with a severe mental illness such as schizophrenia, schizoaffective, and bipolar disorder. We support this bill for 2 reasons. First, non-lethal means are sufficient to defend and protect the society, and therefore the state of Texas ought to limit itself to such means. Second, while wrongdoing permits punishment, individuals with severe mental illness have decreased moral culpability. Advances in psychology and neuroscience confirm for us that capital punishment is not proportional to the offense, given that these individuals with mental illness may not be able to exercise rational judgment or understand the nature, consequences, or wrongfulness of their conduct. To execute such an individual does not satisfy the requirement that the state safeguard the common good or uphold justice. Each week, our prison ministers call to repentance those inmates who have lost hope and whom the world has given up for lost. They do so because God desires all men to be saved and to come to knowledge of the truth. Therefore, in the face of crime, we work to console the suffering, rehabilitate offenders, and call upon the state to protect society using means which recognizes the dignity of each human person. We ask for your support of HB 727 to promote a culture of life, due process, and true justice in Texas.
Jenny, thank you very much. Members, do we have questions? Ms. Andrews? No? Thank you. Chair calls Greg Hanch.
Good afternoon. My name is Greg Hanch. I serve as Executive Director of NAMI Texas, which is the Texas affiliate of the National Alliance on Mental Illness. My testimony is in support of HB 727. NAMI Texas is dedicated to building better lives for the millions of Texans affected by mental illness. We have 27 local NAMI affiliate organizations across the state and approximately 1,700 members made up primarily of individuals and families whose lives have been affected by mental illness. HB 727 would create a narrow exemption from capital punishment for individuals with certain severe mental illnesses at the time of their offense. The exemption would only apply to individuals who had active psychotic symptoms that substantially impair the person's capacity to appreciate the nature, consequences, or wrongfulness of their conduct or exercise rational judgment in relation to their conduct. It would only apply to individuals with schizophrenia, bipolar disorder, or schizoaffective disorder. If convicted, the only other sentence available to a defendant who receives this exemption would be life without parole. In considering this proposal, it's important to understand the nature of the mental health conditions covered. The three conditions are discrete medical conditions diagnosable under the standard diagnostic tool in the mental health field, the DSM. Schizophrenia and schizoaffective disorder affect less than 1% of the adult population. Bipolar disorder affects less than 3%. The common thread among these three diagnoses is that their symptoms often, but not always, include psychotic features, meaning loss of touch with reality. This means one of two things: hallucinations, seeing or hearing things that aren't there, or delusions, which are false beliefs. These illnesses marked by these features, while treatable, can be profoundly disabling without proper treatment. An individual's ability to engage in school, work, family, or life itself is often compromised. Furthermore, these illnesses can push an individual into the criminal justice system. Over 50% of prisoners in the Texas prison system have a mental illness diagnosis. We've made great strides as a state to strengthen community-based care, early psychosis interventions, and criminal justice diversion initiatives, but our work to build up a person-centered, highly accessible mental health system is far from complete. And our state's jails and prisons are far too often used as warehousing entities for the most severely ill Texans. So it's a bit unusual for NAMI Texas to be advocating for a bill that would keep a segment of the severely ill population behind bars. Usually we support getting people out of that setting and into treatment. But the small population of people that we are here for today are those guilty of capital murder who meet the very narrow exemption criteria established by the bill. We support holding them accountable. We support justice for the victims and the victims' families. What we cannot support is a capital punishment paradigm in this state that ignores the fundamental nature of severe mental illness. Executing a person for a crime committed while they were actively psychotic flies in the face of brain science's modern understanding of severe mental illness. It disregards what we know about the lives of people like Andre Thomas, who has suffered from severe mental illness throughout his deeply traumatized life and who clearly falls well short of meeting the Supreme Court's competency standard for execution. I am happy to explain the mechanics of the bill in greater detail. I would also like to note the bill promotes a more efficient use of public resources. While the long and onerous and expensive process plays out of trying to execute a person with severe mental illness, the victim's family waits in limbo, not knowing what the punishment will look like for years and sometimes for decades. In conclusion, HB 727 provides Texas an opportunity to better serve the purpose of justice as it relates to capital crimes. It is broadly supported by stakeholders in the mental health, disability, and faith communities. I thank you for giving me the time to speak in support of the bill.
Great, thank you very much. Members, do we have any questions on the mechanics this time? No, thank you very much. Chair calls Raul Schoenman.
Good afternoon, Chairman Moody, members of the committee. My name is Raul Schoeneman. I'm a clinical professor at the University of Texas School of Law. I'm here just representing myself, and I'm speaking on the bill. HB 727 would bring, excuse me, I'm going to skip ahead. I have some written testimony I'm submitting. I'm not going to read from it. I'm just going to highlight a few points. HB 727 would provide that a person with severe mental illness is defined as a person with 3 discrete mental health conditions: schizophrenia, schizoaffective disorder, or bipolar disorder, and who has active symptoms that substantially impair the person's capacity to appreciate the nature, consequences, or wrongfulness of the person's conduct, or exercise rational judgment in relation to the person's conduct, may not be sentenced to death. This bill would bring Texas law in compliance with the 2005 resolution of the American Bar Association, which called on all states that have the death penalty to protect and exempt persons with severe mental illness from execution. Every major mental health organization in the United States, including the American Psychological Association, the American Psychiatric Association, and the National Mental Health Association, have called on states to protect this class. Some of the prior speakers have mentioned the Supreme Court has already created an exemption for persons with intellectual disability, and this committee is considering a bill to provide a procedure to protect that class. It's often been commented that persons with severe mental illness are much like persons with intellectual disability in terms of their vulnerabilities and their limitations in defending against criminal charges, in that they have the same type of reduced moral culpability for the offense that we already recognize with respect to persons with intellectual disability. There's been polling to the extent that this reflects sort of the consensus in the community about the propriety of imposing a death sentence or carrying out a death sentence on a person with severe mental illness. The polling that has been conducted has consistently shown that while as many as 70% of respondents supported the death penalty, for example, in a national Gallup poll in 2002, 75% opposed the death penalty for persons with mental illness. And that was also significant because a higher percentage of the population favors protection of persons with severe mental illness than favored protecting the class of juvenile defenders, which is already a protected class. So there is, I would submit, a national consensus that this particular class should be protected from capital prosecution and imposition of the death sentence. Unless there are other questions, I'll...
Thank you very much, and I appreciate you breaking it down for us. Members, do we have any follow-ups on that? Thank you for breaking that down for us.
Thank you.
Chair calls Mara Robbins.
Good afternoon. My name is Mauro Robbins. I'm a supervising attorney over at the Office of Capital and Forensic Writs. As you may know, we're the public defender agency that represents people on death row in their post-conviction litigation. Our executive director is on the road in court today, so I am here offering testimony on House Bill 727 on OCFW's behalf. Try to be as brief as possible. Basically, in our view, the bill both fills a gap in the law and it will save courts significant time and money both before and after trial. When I'm talking about the bill filling a gap, I'm referring to what you've heard others talk about here already, that the law already exempts juveniles and people with intellectual disability from being executed because the courts have recognized that the death penalty is for the worst of the worst, and neither juveniles nor people with intellectual disability fit that description because their capacity to reason and to exercise judgment is compromised by factors that are not of their own making. The same description applies to people who suffer psychosis, delusions, and other symptoms of severe mental illness. So it just makes sense for the law to treat people with severe mental illness the way it does people with intellectual disability and juveniles, at least when it comes to the most severe punishment. So by doing this, House Bill 727 would plug that disparity in the law. Turning to the fiscal side of things, the bill also seems likely to save significant time and money in a couple ways. Most obvious savings come up front, on the front end of the process during trial. That's because the bill on its face would stop courts from having to hold lengthy and costly penalty phase hearings when defendants are found to clearly suffer from severe mental illness. But this bill would also save time and money after the trial. And that's because defendants' mental illness do not go away when they go into solitary confinement on death row. Instead, their mental illness often becomes the focus of post-conviction litigation. So one example is it's not uncommon for questions to arise about whether a person who's severely mentally ill is competent to be executed, meaning do they know, even understand enough about what's going on to be executed. As you heard before, the case of Scott Panetti is probably the best known one here in Texas, but there are plenty more. Our office has represented multiple people in this posture, and there are many others around the state. So litigating that question of competency to be executed is time-consuming, it's resource-intensive, and what's more, this litigation recurs. It doesn't, because when somebody is found incompetent to be executed, the case does not end there. Instead, courts have to circle back periodically to see if the person's condition has improved. But if this bill was the law, the people that are most likely to be focus of this kind of litigation would be sentenced to life in prison at the front end of this process, and all the questions about litigating their competency to be executed would disappear. So, as always, our office is happy to be a resource if committee members have questions down the road. Thank you for your time and your attention.
No, thank you very much. I appreciate you, giving us an idea of the gap that exists from your all's perspective.
Thank you.
Members, do we have any questions? Don't get away too fast. No, I was kidding. No, I think we're good. Thank you. Okay, is there anyone else wishing to testify on, for, or against House Bill 727 at this time? Wait, Chair recognizes Representative Rose to close on the measure.
Thank you, Mr. Chairman. I would like to thank all of those who came and testified in support of House Bill 727. I just want to keep and continuously reiterate that this bill, it placed the burden on the defendant. You know, they have to prove at the beginning, or their team have to prove at the beginning of the trial that the person had a mental illness at the time of the offense. And I really appreciate, I know that some of my colleagues are, still kind of leery, but we can kind of visit a little bit more and have more conversations about it. But again, we're not saying that people go scot-free. I just want to keep reiterating that because that's what people keep telling me. They don't think that people should be free if they commit a crime. And we're not saying that. We're just talking about the culpability of a person at the time of the offense. And so, Mr. Chairman, I would appreciate this committee's favorable consideration of House Bill 727, and hopefully you vote it out and favorably and sent to the general calendar. Or can it go to the consent calendar?
We're gonna think about it a little bit. No, I appreciate that. I know that you're in the process. Thank you. I know you're in the process of having conversations with members of the committee, and I appreciate all the work that you've done on this over the years. Members, do you have any questions of Representative Rose at this time? No? Okay, thank you, Representative. If there's no objection, House Bill 727 will be left pending. Is there any objection? The chair hears none, and House Bill 727 will be left pending at this time. Just for housekeeping, I see Representative Collier, Representative Meyer, Representative Jones, Representative Johnson. So right now, I've got Representative Collier, Representative Meyer, Representative Johnson, Representative Jones. Have other people on the calendar, so that may shift as we go, but that's what we've got right now. So at this time, Chair lays out House Bill 798 by Representative Collier and recognizes Representative Collier to explain the measure.
Good afternoon, Chair Moody and members of the committee. It's so good to be back here in front of you, but on this side. So I'm grateful for this opportunity to present House Bill 798. Currently, the Crime Victims Compensation Fund provides a one-time payment for relocation and rental expenses for victims of sexual assault and child victims of attempted murder. However, the statute limits payment eligibility to those who were victimized in their place of residence. The strict interpretation of those three words has a very significant impact, as it forces staff at the Office of the Attorney General to deny those who are victimized in other shared spaces, such as dorms or apartment buildings, even if the assault takes place in another part of the apartment complex. Roughly 80% of victims of sexual assault are assaulted at locations outside of their place of residence, whether that location be a public space or the home of a family or friend. These survivors experience undeniable trauma, and by removing the place of residence clause from the Crime Victims Compensation Act, House Bill 798 would give the Attorney General's office the authority to consider claims for these victims, because those who are assaulted outside of their home should be eligible to receive assistance for relocation and housing expenses to begin their journey to recovery. With the passage of House Bill 798, more survivors will be able to have the resources to help secure housing and seek refuge from those who have assaulted them. I would also like to take a moment to acknowledge and recognize and point out the fiscal note associated with this bill. The Office of the Comptroller states that very clearly on the third sentence of the second page of the fiscal note that no fiscal impact is anticipated from the bill. However, although the fiscal note also states that there will be a cost of $8.96 million over the next 5 years, it's important to note that none of those dollars will come from general revenue. In fact, the Crime Victim Compensation Program is funded through a combination of state dollars and federal matching grants in a separate account, and it's line item 0469. And it's funded through court costs from defendants convicted under certain sections of the Penal Code, as well as other fees such as inmate telephone calls. That account, 469, is not reliant on legislative appropriations for its operation, meaning that the functions outlined in this bill would not require additional funding from the legislature. I know it's confusing. It looks confusing. And I have a resource here that can help clarify that too as well. But the Attorney General's office has shared with my office that the cost of expanding relocation assistance to a greater pool of individuals will be able to be absorbed by the existing fund that is there, the funds that is right there now under account 469. So I have a resource witness here from the Attorney General's office if you have any questions. I'm also open for questions, and with that, I ask for your favorable consideration.
Thank you, Representative Collier. Members, do we have any questions for the representative? And I know that we do have someone here from the Office of Attorney General. We'll have them switch to testifying if you all have questions for them. Does anybody want to visit with?
I do want you to hear from them about this being absorbed within the existing, like this is a program that can.
Let's do that. Can you go ahead and toggle that over to testifying? Chair calls Kristen Huff.
Good afternoon. My name is Kristen Huff. I'm the Deputy Chief of the Crime Victims Services Division of the Office of the Attorney General, and I'm here as a resource witness.
So specifically to what Representative Collier was asking, can you go through kind of how this would be absorbed?
So the funding for Crime Victims Services Division for the Crime Victims Compensation Program, for which this bill is specifically attached, is funded through Fund 469. That is a constitutionally dedicated fund. That is, revenue is only coming from court costs, fees of offenders. It also comes a little bit from restitution, a little bit from subrogation. As the representative mentioned, we are matched fiscally by a federal grant, so a portion of our expenses are reimbursed from the federal government after we expend them. But the state dollars are exclusively from the revenue of court cost, fees, and offenders, and then the federal grant money is also federal criminal defendants as well, so it's similarly appropriated, if that makes, they stole it from Texas, I'm sure. So that's the explanation of the two funds.
Okay. And then what is the interplay with this bill? This bill becomes law.
If this bill becomes law,
does that impact the fund?
the impact on the fund will be an increase in approximately 544 cases. That's an estimate, of course. This population that is currently excluded, they would already be approved for compensation as victims of sexual assault or specifically aggravated assault. The other part of this, in addition to sexual violence, is also attempted murder of children. That bill passed, I believe, either the 87th or the 86th session. We have not seen that very matured, but that includes the in the residence provision. So if someone attempts to kill a child, that family may relocate, but only if that attempted murder was in the home. Most commonly seen in what we would call drive-by shootings or shootings at a residence. This would include children who are almost murdered in other locations, like potentially school. That would be another population. So this is estimated to increase the amount of rent and relocation, which is a very specific type of compensation, up to about 2,000. I think we estimate 2,700 is about the average for relocation that we pay on a claim. This would increase that by about 544 the first year. We get a 3% increase every year in our applications, and that's just with population growth. So when we are looking at the aggregate, for context, the 469 is about it's a very healthy fund right now. It has a large, well, it's a solvent fund, which is nice to say. We haven't always been able to say that, but the fund is very healthy right now.
That's good. That is very good because it goes to good cause. Members, do you have questions for the Attorney General's office? No? Thank you so much. Is there anyone else who wishes to testify on, for, or against House Bill 798 at this time? Chair seeing none, recognize Representative Collier to close on the measure.
Thank you, Mr. Chairman and members. As you heard, that this is not going to come out of general revenue, that the fund would fund it itself. And with that, I ask for your favorable consideration and vote yes on this bill. Thank you.
Yes. Representative Darby.
Thank you, Representative. Just a question. Seems like this victim's fund is focused on trying to remove the child or the victim from the place where the assault took place, which is in their home, and so they need assistance in doing this. But your bill strikes at opening that up to wherever they've been assaulted. Why do they still need relocation dollars if they weren't assaulted in the house?
So right now, if you were assaulted in the laundry room of an apartment complex that you live in, you would not qualify for your services. So this is giving the authority to the Attorney General's office to look at those situations. I think what you're talking about, if you were assaulted, say, for instance, at the park, even then, I would think that that would be something that somebody may want to move away from that area to help with the process of healing. But I believe in that situation, it would be left to the Attorney General's office to determine. We just don't want to tie their hands to say it has to be the place of residence to be eligible for these services.
Should there be a nexus between the place of assault and where they're trying to locate from? I mean, to me, again, if they're assaulted in the laundry room of the apartment, yes, there's a nexus to where they're living. They need to be relocated. But if they're assaulted in a park, are you suggesting that the Attorney General could say that they need to be relocated?
I would.
And the cost of that relocation come out of this fund?
I would say that that should be something that should be considered. Right now, they're not even they can't even consider that. I mean, I think that if you take into the totality of the circumstances, so if it was a park that was, in another city where they live, then maybe not, they don't. But if they have the park that's up the street from their home, maybe they want to move from that area because it brings bad memories. Maybe they don't have, anything fond about that area anymore because of their trauma. And, it's not for us to determine how it impacts them, because everybody handles trauma differently. And so, yes, it may be that I need to move because of whatever attempted crime happened at that park. I mean, if it was attempted murder of a child at the park, then maybe I don't want to have my family there. So I think that, yes, I think that it would open it up and for the Attorney General's office to consider that.
So is there language in your bill or language in the existing statute that allows the Attorney General's office to form a nexus between the place of assault and the need for them to relocate, to be eligible for relocation? I can understand crime victim compensation, which is different than, I think what you're asking is relocation.
That's right. Rent
expenses.
Yes, sir.
So does your bill create the nexus between those points, i.e. where the assault took place and where they're trying to move from, and the reason why they're trying to move from there?
I think that
is my question.
In my opinion, it would be implied because it just removes that, but I'm happy to work with you on crafting language if that's one of the concerns that you have, because to give them the explicit ability to, make a judgment call or on something like that. I think that they already have that. We just don't tie their hands right now. By removing that place of residence, it gives them more ability and freedom to take into account the totality of the circumstance. I think that it's accomplished by just removing that place of residence, but I'm happy to work with you if that's a concern that you have.
Thank you, Mr. Chairman.
Thank you, Representative Darby. And Representative Schatzline, I know you had some questions.
Yeah, thank you so much, Mr. Chairman. I just wanted to address that question specifically in defense of the bill. One of the things that we've worked with, especially at-risk kids, me and my wife, we've dedicated the last 12 years for. I love this bill because ultimately, if an assault took place on a public school campus, one of the greatest things we can do for a student is give them a fresh start. Sometimes that's moving outside of that neighborhood. Sometimes that's relocating schools. And so I can totally understand the merit behind needing relocation for something like that, even if it's not on residents, just so that they can kind of have a fresh start. It's one of the key components that we've worked with at-risk kids when it comes to some of these assaults. So I just wanted to speak to that one because in my experience, it's incredibly helpful when they can have a fresh start and just start over, especially in their healing process. So
thank you. I appreciate that.
I know that if you want to ask a question of Representative Collier, you have to come up here. Okay. So I just want to make sure members of the committee had an opportunity first. Representative Jones, did you have a question?
Representative Collier, you practice criminal defense?
I do not.
Okay. All right. Well, what I was going to say as a practicing criminal defense lawyer and a survivor of domestic violence and crime, would your bill, you familiar with protective orders or MOAPs, magistrate's orders of emergency protection, where if you've been a victim of somebody, the courts will say you can't be within a certain amount of space, whether it's 1,000 feet or 200 feet, and generally that protects the home. So are you aware that some perpetrators of crimes will not get you at your home because they'll be charged with violation of a protective order and they're trying to skirt the law and they'll get you where they can find you? So would your bill, did it consider anything like that when not tying it to the residents?
Well, that's exactly what I talked about. I said about 80% of the crimes for sexual assault and child attempted murder happen away from your place of residence. And so that's why we're saying let's expand who qualifies, who's eligible for these services to those who happen to have, who are victimized outside of their place of residence.
And did your bill contemplate if you're a victim of a crime from whomever, and they know where you live, regardless of where they assault you or try to kill you, that doesn't matter where the assault happened. What matters is that you're at a place where you can be safe and you don't always have the money to get there. So your bill would help with that.
Absolutely. And again, it's only sexual assault and child victims of attempted murder. Yes.
Thank you.
Thank you.
Thank you. Representative Harrison, did you have a question?
Yeah, thank you, Chairman. Just two quick clarifying questions. Thank you very much, Representative Collier. Just to follow up on the dialogue with Representative Darby a minute ago, I want to make sure I heard you correctly. It sounded like there might be some openness to what I hear is your concern about the current law being overly restrictive with the use of the terms place of residence with that language. But to Representative Darby's point, did I hear you there might possibly be some openness to considering not going from the status quo, which is, in your perspective, overly restrictive with those language, but not necessarily having to move to something with zero geographic or other types of restrictions? You might be open to something kind of in the middle that I...
No, I'm not.
Okay.
This is what I'm here for.
Yeah, I appreciate it. That's why I
believe
wanted to clarify.
Okay, yeah.
Thank you, yeah.
I want to remove the place of residency restriction, but what I am open to is having the Attorney General set the rules so that they can have that flexibility to take into the totality of the circumstances.
Okay.
So if it's not explicitly stated, which is what Chair Darby is asking, if it's not explicitly, do they have the authority or the ability to make a judgment call? And I believe that they do, but if there's something that would make you feel more comfortable to have language in there that says that they can review it themselves and make a decision, then I would be open to that.
Right. No, that's very helpful, and thank you for the clarification there. And then one other clarification, and I don't know in terms of like how the fund gets utilized on a year-to-year basis, but is there any concern if it were broadened about the sufficiency of the fund? You know, if all of a sudden X number of people today can qualify for it, but X plus, Y next year, if these changes were made, broadens the number of people who could participate or receive funds or receive proceeds from that fund. Is there any concerns about the fund's ability to have enough resources to accommodate the increase in people that could utilize it?
Not to me, because again, it's funded by people who commit crimes. So if we can get everybody to stop committing crime, we won't need this bill. We won't need this.
A goal we all share.
Yeah, but again, I heard, just like you did, from the Attorney General's office that said that the fund is solvent. It's in good shape right now.
Yep.
So I don't believe that it's in jeopardy.
No, appreciate it. It was just asking, if we broadened it, would they still have that view?
I'm only here for this,
Yep.
and they anticipate 544. Now, there may be another bill that would do it, and then, of course, you want to,
Right.
but right now, today, I have this.
No, thank you for the clarification. Thank you, Chairman.
Recognize Representative Bowers has joined us. Let me do this before you close, and if I could ask the Attorney General's office, just to help us. These are applications that people go, there's a process of application people go through. No, I'm just going to ask for some background information. If you could supply us with what those applications look like, just for our, I know that in my time at the DA's office, way back when, right, people fill them out, send them in. We had victim services send those to OAG's office, and then they review them. The language of this bill in front of us is a may, right? This is something that could be considered. So I think what they're trying to do is take I think the goal of the bill is take the restrictive nature of the language because it's being interpreted a certain way to be able to figure out how these applications can then be considered. But if there's any information on the application process that you could share with us, just, whatever forms you've got or whatever you've got in terms of that. No, if you can follow up with information and we'll provide it to the committee. Let's do it that way. And I appreciate that, but I think it'd be good for them to know the nuts and bolts of what that looks like. Because it's not send in a paper and money comes back the other way. So there's a process that I think it'd be good to kind of, for all of us, to refresh my memory is how it works as well. Members, do you have any other questions? No? Okay. And you close?
Yes, sir, I
All right,
close.
thank you, Representative Collier. If there's no objection, House Bill 798 will be left pending. Is there any objection? The chair hears none, and House Bill 798 be left pending at this time. Chair lays out House Bill 409 and recognizes Representative Collier to explain the bill.
Thank you, Mr. Speaker, Chairman. Oh, excuse me, Chairman.
I'm not going to stop you.
Yeah, yes, sir. Thank you, Mr. Chairman, members. The board of the Texas Indigent Defense Commission is amazing. And they're currently composed of 5 members appointed by the governor. They're judges, defense attorneys, and public defenders. However, the current composition fails to account for 2 other participants in the indigent defense system. Those are the Managed Assigned Counsel Program and magistrates. So House Bill 409 will address this. So in Texas, many indigent defendants are represented through the Managed Assigned Counsel Program. We call it the MAC. And currently, Texas has 7 MAC programs located in Bexar, Collin, Harris, Lubbock, McLennan, and Potter, and Travis counties. But the number is expected to increase over time. Given the scope of the representation provided by these programs, it only makes sense for them to be represented on the TIDC board. They need a seat at the table. Additionally, although the involvement of magistrates is limited to the initial stages of a criminal case, the significance of their role in the criminal justice system cannot be overstated, especially as it relates to indigent defendants, and that impact in and of itself necessitates representation to ensure that their perspective is taken into account as the state seeks to improve our indigent defense system. So to address that, HB 409 would modify membership of the TIDC's board by requiring the governor to appoint 2 additional members, bringing the total to 7. The 2 members would be a director of a Managed Assigned Counsel Program and a justice of the peace, municipal court judge, or appointed magistrate who regularly presides at Article 1517 hearings. Including these members would provide a unique and direct perspective on the current state of indigent defense in Texas, as MAC programs are essential to providing necessary counsel and legal advice to those who are unable to afford or retain their own legal team. Additionally, HB 409 would remove the ability for board members who are chief public defenders to pick a designee. I understand that this is some problematic language about the appointment, and you'll hear from the TIDC executive director more about that. And it also requires a MAC director member to recuse themselves for votes regarding an award of funds to a county that the MAC serves, as is the existing case for a chief public defender serving on the board to preserve the board's ethical obligations. We have witnesses to speak on the bill, and with that, I reserve the right to close.
Any questions from Representative Collier? Thank you very much. We'll proceed to testimony. Chair calls Jeff Burkhart.
Good afternoon, Mr. Vice Chairman and members. My name is Jeff Burkhart. I'm the Executive Director of the Texas Indigent Defense Commission, and I'm testifying as a resource witness today. The bill, as Representative Collier laid out, does 2 things. It expands our board from 13 to 15 members. That includes the addition of a Managed Assigned Counsel Director and the addition of a magistrate. It also ensures that our board would have representation from a chief public defender. In years past, it could be a chief PD or a designee. The problem, what we've seen in the past with the designee, is a lot of times there were questions about whether they could speak for the public defender office. There may be different opinions between the representative and the chief. This bill, the proposal did go through our legislative work group, which includes defense attorneys, judges, prosecutors, and it had unanimous approval there, as well as with our board. Our board unanimously approved this at one of its board meetings a couple of sessions or quarters ago. With that, I'm happy to take any questions you might have. Thank you.
Members, any questions? Mr. Burkhart? All right, thank you, sir.
Thanks, sir.
Chair calls Bradley Hargis. Mr. Hargis, if you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill.
Thank you, Mr. Vice Chair and committee members. My name is Bradley Hargis. I am the Executive Director of the Capital Area Private Defender Service, one of the MAC programs in Texas, and I'm testifying in favor for this bill. So Managed Assigned Counsel has become a large feature of indigent defense in Travis County, as you heard from in Texas. As you heard from Representative Collier, the Managed Assigned Counsel programs have expanded around the state. It has become a large contributor. Our program was started in 2014. It became the largest at the time in the state, and a third program to be launched. Since that time, we have made over 140,000 assignments to defendants, and we currently manage 85% of adult indigent cases in Travis County. Managed assigned counsels work with public defenders in the communities where public defenders exist as a partner, maybe as a sibling to those systems. Managed assigned counsel is a method of indigent defense that does differ from the concerns of a public defender. And so I do strongly support the recognition that TIDC would benefit from the perspective of managed assigned counsel director on its board. It has become a major funding option for the Texas Indigent Defense Commission. And some of the differences between what a public defender office faces and what a managed assigned counsel office faces does necessitate, or the board would benefit from having both perspectives on their board to provide them and guide them in their decision making, and not just one or the other. I'm happy to take any questions you have about managed assigned counsel. I know that it may not be something everyone is familiar with, as it is a more recent addition to indigent defense, especially here in Texas. But I think that this bill would strongly support the managed assigned counsel maturity and taking the next step.
Thank you, Mr. Hargis. Is there any questions for the witness? All right, thank you, sir. Thank you for your testimony. Chair, next call is Judge Nicholas Chu. Judge Chu, if you would please state your name, who you're here on behalf of, and your position on the bill, if you're on for or against the bill.
Sure. Thank you, Mr. Vice Chair and members of the committee. My name is Judge Nicholas Chu. I'm the Justice of the Peace for the Capital Area. I'm here on behalf of the Justice of the Peace and Constables Association, testifying in support of the bill. Adding a magistrate, whether it be a Justice of the Peace, a municipal court judge, or a criminal magistrate under the Code of Criminal Procedure would give a needed perspective in the commission in terms of how the commission regulates and does business in terms of indigent defense work. The 800 plus JPs in Texas do the majority of magistration in Texas. When you add the municipal court judges and the criminal magistrates, that represents pretty much everybody in the magistration business. In that scenario, magistration is one of the most important parts to kickstart indigent defense. It creates the initial appearance that then creates the right to counsel, and then also the judge there has to then create the appointment, ask a defendant if they would like an appointed counsel, see if they qualify for an appointed counsel, and then send off those notifications to the proper entity. So that kind of work that we do in terms of kickstarting indigent defense work, I think that perspective would be a welcome perspective for the commission. With that, are there any questions?
Members, any questions for Judge Chu? Thank you, sir. Thank you for your testimony. Is there anyone else here who wishes to testify on, for, or against House Bill 409? Hearing none, Chair recognizes Representative Collier to close on the bill.
Thank you, Mr. Chairman and members. I appreciate you listening very attentively to this, and I ask for your favorable consideration. I close.
Thank you, Representative Collier. If there's no objection, House Bill 409 will be left pending. Is there any objection? The Chair hears none. House Bill 409 is left pending. Chair, next call is House Bill 1161. House Bill 1161 by Chairman Meyer. Excuse me.
Thank you, Mr. Chairman, committee. Members, currently Texas address confidentiality statute explicitly provides protections for survivors of family violence, sexual assault or abuse, stalking or trafficking of persons, but child survivors of abduction are not identified as eligible program participants. Child abduction survivors and their families are susceptible to harassment and attempts by perpetrators to initiate unwanted contact, including continued threats of criminal activity. HB 1161 seeks to prevent these cases by keeping survivors and their families' addresses private and confidential. HB 1161 was brought to my office by the National Center for Missing and Exploited Children. Thank you, members. I believe there is a resource witness from the Attorney General's office should you have any questions. And with that, I reserve my right to close.
Great. Members, any questions for Chairman Meyer? All right. Thank you, sir. If there's no further questions, we'll proceed to testimony. Chair calls Kristen Huff. Ms. Huff, if you would please state your name, who you're here on behalf of, and your position on the bill.
Good afternoon. My name is Kristen Huff, Deputy Chief of Crime Victim Services Division for the Office of the Attorney General. I am the attorney for the Address Confidentiality Program, as well as the Crime Victims Compensation Program. I'm here as a resource witness to answer any questions about the ACP program, if you have them, the current statute, and what this bill might do.
Members, any questions for Ms. Huff? All right. Maybe run while you can. If there are no further witnesses, is there anyone else here that wants to speak on for or against House Bill 1161? If not, Chair recognizes Chairman Myers to close on House Bill 1161.
Thank you, Mr. Chairman. Members, it provides a needed protection for those victims of child abduction. Thank you for that, and I close. Appreciate it.
Thank you, sir. But, is there any objection to House Bill 1161 being left pending? Hearing none, House Bill 1161 is left pending. Chair next calls House Bill 55 and recognizes Representative Julie Johnson to lay the bill out.
Thank you, Mr. Chairman and committee. I appreciate the opportunity to talk to you today about House Bill 55. Currently, there is no provision for felony enhancement for any non-penetrative behavior committed by individuals, even in the case of multiple similar attacks on a variety of people. House Bill 55 amends the Texas Penal Code relating to indecent assault to allow for felony enhancement of non-penetrative sexual assaults if the perpetrator is a repeat offender and/or healthcare services provider who performs the act during the course of those services. Indecent assault would be enhanced to a state jail felony if the actor has been previously convicted of indecent assault or if committed during the course of providing treatment by a healthcare or mental health care service provider. Indecent assault would be enhanced to a third-degree felony if the actor was previously convicted as a mental health or healthcare services provider. Last session, this bill was voted unanimously out of this committee, and I reserve my right to close.
Members, any questions for Representative Johnson? All right, thank you. Hearing none, we'll move to testimony. Move any witnesses? Chair recognizes Jay English. Mr. English, if you would please state your name, who you're here on behalf of, and your position on the bill, on, for, or against.
Yeah, good afternoon, committee. My name is Jay English, and I'm here speaking in favor of House Bill 55, which amends Criminal Code 22.01 to allow for felony enhancement. I'm here really speaking on behalf of my clients who were victims of these kinds of assaults. I represented 5 women from Weatherford who were assaulted by a cardiologist in the course and scope of what they thought were regular and routine cardiological exams. I also represent as the mouthpiece of the 22 anonymous victims who came forward after this event came to light in the media and because of various reasons withheld their names, but easy counting, that's 28 total victims of molestation in the course and scope of this cardiologist's practice. It's important for me to name my clients. They are named as, they have been in all legal filings as SW, JW, KP, PW, and SJ. All of these folks had their breasts molested. Some of them had their pubic areas molested. All of them were the subject of inappropriate comments. And interestingly enough, all but one thought that things were weird, but it was their doctor, and so they trusted him. And so these women were as young as 18 years and 1 month. They were as old as 76. Some of them had large breasts, and some of them had had mastectomies. They had been his long-term patients, and one of them had been his first patient. It was certainly a tragic story. As I mentioned, these folks were victimized, in my opinion, 3 times. One, the victimization by the cardiologist in the course and scope of the examination. And I think we can all agree that that's horrifying. But secondly, many of my clients were victimized by the fact that because this was a healthcare provider, because they trusted him, and because they were in a place where they expected that there was a relationship that they could trust, these folks typically did not realize fully what was going on with them. despite the fact that other members of this gentleman's practice and every cardiologist, expert witness of any kind that we ever spoke to said that this type of behavior in no way could be considered part of a legitimate cardiological exam. As Representative Johnson has pointed out to you, despite the fact that this gentleman had multiple victims in this setting, because there was no penetrative behavior, it did not matter the setting that it was in or the number of people that had been victimized. In spite of all of that, the district attorney or the Parker County attorney could only charge this man with a misdemeanor. Again, it felt like my clients were experiencing not the first, not the second, but now the third victimization.
Mr. English, if you can please finish up your testimony. Your time is out.
Okay, let me just say to the committee that the way things are today is that this physician pled guilty to one count of violating the Texas Medical Practice Act, which was a misdemeanor for which he received deferred adjudication. There was no registration of any kind as a sexual offender. The man had his license yanked only long enough to allow for his probation to be completed. And now that physician is a practicing physician with no sequelae in the state of Texas.
Thank you, Mr. English. I just want to clarify that you are testifying on your own behalf today, right? You're not representing.
That's correct, as the mouthpiece of my client.
But for
that
yourself.
That is correct. That is correct.
All right, thank you, Mr. English. Any questions? Chair recognizes Chairman Leach.
Thanks for your testimony. Just want to get a few other details. When did these incidents take place?
Gosh, 4 years ago.
4 years ago?
Mm-hmm.
Okay. Did any of the victims whom you represent pursue civil claims?
They did.
And do you have those claims been adjudicated?
Those were the only good result that these folks were able to obtain.
In a
civil context.
In a civil context. Which county was that?
The Tarrant County.
It was Tarrant County? Okay. Okay, thank you.
You bet.
Thanks.
Members, any other questions for Mr. English? All right, thank you, sir.
Thank you so much.
Are there any other witnesses here today that would like to testify on, for, or against House Bill 55? Hearing none, Chair recognizes Representative Johnson to close on the bill.
Thank you to the committee. You know, I think we can't have repeated offenders. People in positions of trust commit these kinds of offenses without any enhanced penalty. So when this will allow prosecutors to pursue more aggressively these people who just deserve to be punished at a higher level. So I would appreciate the committee's favorable conclusion and pass out, and I close.
Chair recognizes Chairman Leach.
Thank you, Representative Johnson. I think this is a great bill, and I look forward to supporting it. And as you know, we've done some good work in recent sessions on the civil statute of limitations on specifically related to childhood sexual abuse and assault. And I think we need to do more of this session. I'm glad to know that your clients were able to seek and obtain some semblance of justice within 4 years. But in my opinion, even if it had been 40 years, they should have been able to pursue and should be able to pursue civil claims as well. I've got a bill to do that, to extend the statute of limitations in the civil context. So this legislature is going to continue to stand up for victims of sexual abuse and assault, and this bill is a key part of that. So thank you.
Thank you, Mr. Chairman.
Thank you, Representative Johnson, and thanks for closing on the bill.
Thank you for the opportunity. I close.
All right. I'm sorry. Is it next? Yeah, okay. Yeah, gotcha. All right, is there any objection to leaving House Bill 55 left pending? Chair hears none, and House Bill 55 is left pending. Chair recognizes Chairman Dutton on House Bill 939.
Thank you, Mr. Chairman. Thank you for hearing this bill. I've been following this bill, I think, since 2003. Before some of you were probably born, but all it does is one thing. Every morning I get up, I have me a cup of coffee. And I usually go get a sweet milk. And I put this in my coffee. That's 1 gram. And 1 gram of marijuana in this state is a state jail felony, which means you can be subjected to 2 years, up to 2 years of incarceration. This bill changes that, so it's now a Class 8 misdemeanor. And that's really all the bill does. And so I'll be happy to answer any questions. There are a lot of stats I could give you about why it's better to do it that way, both medically, economically, for taxpayers. But that's what this bill does. And with that, I'll be happy to answer any questions, Mr. Chairman.
Thank you, Mr. Chairman. Members, any questions for Chairman Dutton? All right, thank you, sir. We'll see if there's any testimony.
Thank you.
Is there anyone here today that would like to testify on, for, or against House Bill 939? Hearing none, Chair recognizes Chairman Dutton to close on the bill.
I close, and this bill didn't pass because the other committees weren't as smart as this.
Thank you, Chairman Dutton, for your wisdom. If there's no objection, we'll leave House Bill 939 pending. Is there any objection? Chair hears none, and House Bill 939 is left pending. Chair recognizes Representative Jolanda Jones on House Bill 476.
Mr. Vice Chair and colleagues, disclose I'm not going to be as smooth as Chair Dutton. What I would like for you to remember when you hear this bill is they've already served their time bill. Again, I want to thank you, Vice Chair, and even Chair Moody, who I knew he was here earlier in the committee. I appreciate the opportunity to speak to you today about House Bill 476, which will amend the Texas Code of Criminal Procedure so that individuals are not detained in jail for a cumulative period that is more than the maximum term of confinement that may be imposed on the conviction of the offense for which the defendant is accused. The criminal justice system is meant to create accountability and righteousness in our society, yet the massive backlog of cases across Texas counties, which was sometimes exacerbated by the coronavirus pandemic, has created a situation where accused individuals are sometimes detained in excess of periods and months to years. Detaining an accused person for extraordinary periods of time violates the constitutional protection against unlawful detainment and continues to further criminalize poverty. Additionally, these excessive detainments cost taxpayers millions of dollars a year. Texas must address this issue to save state dollars and ensure justice is properly administered in our state. HB 476 will ensure that Texans don't stay locked up longer than the maximum sentence before their trial. We are also anticipating a committee sub that will provide exceptions for certain individuals. One is people awaiting competency and restoration, because sometimes that takes longer than the maximum range of punishment. Also for Class C misdemeanors. It's really interesting. I've been a criminal defense lawyer for a long time. And while most people can afford misdemeanor bonds, some people cannot. And they stay locked up. Sometimes you also have prosecutors who are like, oh, you might beat the rap, but you're not gonna beat this ride. So one of my clients was charged with a Class A misdemeanor, which, for those of you who don't know, the range of punishment for a Class A misdemeanor is up to a year in the county jail. But he didn't have a trial within a year. So he was actually locked up on a pretrial detention, and I would also remind my colleagues that if my client had gone to trial and gotten convicted and got imposed a maximum range of punishment, my client would have only had to be locked up for a year in the county. And in Harris County, actually, they're given 3 for 1. So in Harris County, if you get locked up, if you get the maximum range of punishment, and you get sentenced to a year in the county, you're gonna be locked up for 4 months, right? Now, so the committee substitute will also include, it'll either be the maximum range of punishment, which again, on a misdemeanor, the maximum time you can be locked up is a year. And state jails as well, which the most you can be locked up for state jail is up to 2 years in the state jail day for day. And it's a problem when you have, I mean, I've had a misdemeanor trial take 3.5 years. I've had state jail charges be longer than 2 years. And all this merely does is it releases on pretrial bond someone who's literally already served their time. And that's what I'm asking for. And there'll also, the committee sub will say, and we don't have that from Ledge Council yet, so when we get that, we'll present it, is that it'll be either the maximum range of punishment or the Harris County Sheriff's time commutation. So in other words, the local sheriffs that hold people who are pretrial, they determine whether they get credit or not. So in Harris County, it's 3 for 1, but some counties it's day for day. So whichever is lower. And so I'm respectfully asking that you vote this out favorably. And I would also remind my colleagues that you're innocent until proven guilty in America. And pretrial detention is just that. You're locked up until you have your day in court. This actually encourages people to plead guilty because they think they can get out faster if they plead rather than wait for their day in trial. So I was actually very shocked to find out that this actually happens, and I learned from personal experience. So, and it basically criminalizes poverty. And hold on, this is the first time I've laid out a bill. Let me make sure I'm not forgetting anything.
Take your time.
I appreciate your time today, and if there are no questions, we have community partners and subject matter experts here to testify and be a resource, and I reserve the right to close.
Great. Members, any questions for Representative Jones? All right. Thank you, ma'am. Have a seat, and we're going to see if there's anybody here to testify. Is there anyone here wishing to testify on, for, or against House Bill 476? Chair calls Lauren Johnson. Ms. Johnson, if you would please state your name, who you're here on behalf of, and if you're speaking on, for, or against the bill.
Yes, sir.
After you pick your pen up.
Throw pins around. Hi, my name is Lauren Johnson. I work for the ACLU of Texas, and I'm here to testify in support of the bill. I just would say that if there were an award for the most common sense bill of the session, I think this bill wins the prize. We talked earlier, and you're going to be talking a lot this session and beyond about the court backlogs, and I think that this is an excellent tool to start chipping away at, just one piece of that. It's going to take a lot of solutions to deal with the court backlog problems, but this is a tool that helps us get there. It's a little bit wild to me that this has not been done already, but in an era where we're hearing stories from people that are spending 5, 7+ years in pretrial detention in county jails, I think that this is a much needed solution for that. Every day that somebody spends in a county jail creates more obstacles. It increases their criminogenic risk. It just compounds on top of each other. And the other thing that's coming to my mind right now is the story of Khalif Browder, who spent a significant amount of time in the New York City jail. He wound up committing suicide later, but he was innocent of the charge that he was jailed for. And when he finally, he spent all that time in the county jail. When he was finally released, the mental health impacts of that were just too much for him, and he took his own life. And I think of him when I think about the support that we have for this bill, and so we hope that you'll consider it favorably. Happy to answer questions, but common sense bill of the session.
Ms. Johnson, I just want to clarify, you are testifying on behalf of ACLU and yourself, is that correct? Okay, great. Members, any questions for Lauren Johnson? All right. Thank you for your testimony. Is there anyone else here who wants to speak on, for, or against House Bill 476? Hearing none, Chair recognizes Representative Jones to close on the bill.
Colleagues, I actually forgot to tell you that this actually is fiscally responsible and conservative. One, it'll get people out of the jail. There's a cost associated with having people in jail. And when I look to the Legislative Budget Board, there will be no significant fiscal implication to the state, is anticipated. So, Texas must not needlessly detain individuals for excessive periods of time. Detain individuals for longer than their potential sentences before they go through the justice system is costly. HB 476 will stop this practice, saving Texas money and creating a more fair justice system. I respectfully ask that you vote in favor of HB 476 after we get the committee substitute. And with that, I close. We request that you leave this bill pending until the substitutes are delivered.
So Chair recognizes Representative Satzline to ask questions for Representative Jones.
Thank you so much. One clarifying question, I think you said it, just for my notes so I can have it. You talked about a committee substitute. You said it was for Class C misdemeanors, for things such as, disorderly conduct, voyeurism, that kind of thing. That's what's going to be in the committee substitute?
So in the committee substitute, I'm sorry if I didn't share that.
You may have.
I think we need to keep the remarks confined to the bill that's before the committee, and so we'll
Right,
wait until there's a substitute before the committee.
Oh, okay.
So you don't want me to tell what the committee substitute will say? Okay, that's cool.
Yeah, just to clarify that there's not a committee substitute before the committee now, but.
No, but it's coming, yes.
And you've already spoken to your.
Yes, people have brought some concerns, and so we're going to substitute that in. But we'll talk about that whenever it's appropriate.
Do you have any other?
No, that's what my question was on. Okay. That's great.
Thank you.
All right, members, Representative Harrison. Yeah, and I think she's given that. I mean, is there anything else that, as far as the committee substitute that you intend to offer, is there anything else you want to speak about?
So yes. So also there are some Class C misdemeanors where there's not like a range of punishment, but PI, for example, right? So that's going to be excluded. That's not going to be a part of it. So you can still get people and put them where they need to be when they need to be there. And it's not going to affect this. So it's just a common sense bill. I agree with the lady before. And again, I just want for you to remember that they've already served their time bill.
Okay. Chair recognizes Representative Harrison.
Thank you, Chairman. Thank you, Representative Jones. Just a quick clarifying question, and maybe this is getting caught up in the committee sub-debate, I'm not sure, but from your perspective, what would be the effect of this on Class C misdemeanors? As I understand, Class C misdemeanors don't come with any accompanying jail time, but I think they can be held for a period of a couple days. Is it your perspective that it would necessarily have the case of reducing Class C misdemeanors to effectively ticket-only offenses, or do you not see it that way?
No, Class Cs are going to be taken out.
In the committee sub?
Yes.
Okay, got it. So that's what I thought. This might be getting caught up in that. No, thank you for the clarification.
Yes.
Thank you, Chairman.
All right, any other questions for Representative Jones? I'd like to close on the bill, correct?
Yes, thank you.
All right, thank you. If there's no objection, House Bill 476 will be left pending. Is there any objection? Chair hears none. House Bill 476 is left pending. Do we have any other members? Chair recognizes Chairman Moody. You want to start with House Bill 180? Chair recognizes Chairman Moody to lay out House Bill 476. Excuse me, what is it? House Bill 180.
There's a sub.
Yeah, it is at the back. The chair offers a committee substitute to House Bill 180 and recognizes Chairman Moody to explain the bill and the substitute.
Thank you. I appreciate it. Substitute in this case is much like my others, which is just a legislative council version. So there's no substantive changes. So I'll go into the substance of the bill. Actually, it's one that Mr. Leach, Ms. Bowers, and I heard quite a bit about during our interim hearings. But I'll touch on that in a second. Uncertainty in the law and conflicts between legal authorities undermine public confidence in our justice system and can lead to some very unjust results. One of the highest profile places this has been on display in recent years is regarding execution dates. Historically, most judges have deferred to prosecutors who request that an execution date be withdrawn. It's been seen as what's called a ministerial duty, not something where the judge makes any kind of decision, but something where the judge is simply required to honor the request and sign the order. The law, however, isn't clear on that point, though, and some conflicts have arisen. There's a couple that we've read about, one out of Nueces County regarding John Ramirez, who has since been executed after the prosecutor in that case said a death warrant was sought inadvertently, and when sought to withdraw it, was denied. That was litigated all the way to the Court of Criminal Appeals. The other instance, which I think, thank God, ended differently, was that of Melissa Lucio, in which a prosecutor told us that they didn't have the power to withdraw the death warrant in that case. It was out of their hands, washing their hands of it and walking away. Now, in that case, the Court of Criminal Appeals did the right thing and sent the case back down to the district court for more evidentiary hearings. But those two cases crystallize why a bill like this is important. Whatever you think about those two cases, and you may have differing opinions about them, this is the kind of conflict that creates awful circumstances in our state. The prevailing trend in most cases is how I believe we should resolve that, which means we should make it clear that the authority resides with the prosecutor. With due respect to any judges who may be here today, I don't know if my dad is watching, but also apologies to him. In a capital post-conviction case, the prosecutor is in a far better position than the trial judge to decide whether an execution date should be set. The prosecutor is privy to all the evidence and all the latest developments in the litigation, while the trial judge may know nothing about the case besides what happened during the trial. In fact, the judge may not even know that, since a different judge may be on the bench by the time of the execution. We need to pick someone. That's our decision. And that should be the person with the most information, our prosecutors, who've taken an oath to see that justice is done. House Bill 180 does that in a very simple way by saying that when a prosecutor requests the withdrawal of an execution date, the judge must honor it. It's very straightforward, but it brings clarity to procedures that should be beyond reproach. I'm happy to answer any questions about it. If there are no questions, I just reserve my right to close.
Thank you, Chairman. Members, any questions for Chairman Moody on House Bill 180? Thank you, sir.
Mm-hmm.
All right, we'll proceed to testimony. Is there anyone here that's wanting to testify on, for, or against House Bill 180? Chair recognizes Jenny Andrews. Is Jenny Andrews present? She's registered for the bill. Okay. If there's no one else here to testify on the bill, Chair recognizes Chairman Moody to close on the bill.
Thank you all. Like I said, very straightforward. We need to pick who makes this decision. Let's make it clear in our law. The confusion that we saw and explored over last summer, and I think showed how problematic this can become. So let's make it clear, and the courts can go from there. But we get to set the rules at the base level. So I'd ask for your favorable consideration. With that, I close.
Thank you, Chairman Moody. The committee substitute for House Bill 180 is withdrawn. And if there's no objection, House Bill 180 will be left pending. Is there any objection? Chair hears none. House Bill 180 is left pending. Chairman Moody, are you ready to move forward on House Bill 205? Chair recognizes Chairman Moody.
Did you withdraw the substitute?
Oh, I'm sorry. Sure. All right, Chair recognizes Chairman Moody on House Bill 205 to explain the bill. And Chair offers committee substitute to House Bill 205 and recognizes Chairman Moody to explain the bill and the substitute.
Thank you, Mr. Chairman. I appreciate that. Same result, we got ahead of Legislative Council, so that's substitute is what, that's just them putting their official stamp on it. I'm sure they recognize the genius of our work, and so moved it over back to you all quickly. Actually, I'm very proud of the work we get to do here in the legislature. It's something that I think we all take great pride in. However, and I'm going to confess this to the new members, we do make mistakes from time to time. And I know that probably is shocking to you. But they do happen. And sometimes those things will create gaps in policy that are very problematic. And that's exactly what this bill seeks to address. I guess it's a good way to build in work for us in later sessions. So it keeps us, I guess, writing laws. That's one good thing. But just to give you some background, years ago, the legislature created something known as a new science writ, which states that when new science arises that a person is able to show would probably change whether they were convicted in a case, a court can overturn their conviction. This has proven invaluable when evaluating forensics that have turned out to be junk science, right? Things like bite mark analysis that are completely bogus, as well as forensics that were once very crude, like we once saw in many arson cases, right? So this allows for later science to catch up in the legal process. However, because the law talks only to whether the conviction happened or not, new science that would have likely changed the punishment a person received doesn't entitle the person to a new punishment hearing. Remember, you have a bifurcated trial, guilt, not guilt, and then the punishment. This writ relief on new science, the way it was written by the legislature by a clerical error, only applied to the guilt, not guilt phase. And you don't really need to look further than a case called Ex parte White. For those of you who want the case citation, I have it. I'll hand it to you later. But it's a good example of how that came up. White was given a death sentence, but new advances in brain science after his trial showed that he may have been much less responsible for his actions than was claimed at trial. Our Court of Criminal Appeals agreed that would probably have led to a sentence of life in prison, but it said that its hands were tied. The law was worded in a way that only provided for overturning convictions, not for changing punishment. Helpfully, the court itself suggested the legislative fix that you see before you in this bill. If you see a theme of things that I bring before you, these have been litigated. The court is asking for the solution. In fact, in this case, they said, we believe we're reaching an unjust result, but we can't do anything because the letter of the law says this, and it's not our job to extend past interpreting what the legislature wrote. So this is just a cleanup that says the new science writs can cover punishment issues the same way they cover guilt issues. I don't think it's anything controversial. Last year it passed out of the House 144-1, and then it got stuck in the Senate, but we're working on that. Chairman Leach, right? And I hope that we can get everything through that chamber this session, including this bill, and I know that this will create a lot of clarity and some certainty in an arena that's been litigated already. Happy to answer any questions. If not, I reserve my right to close.
Members, are there any questions for Chair Moody? All right, thank you, sir. We'll proceed to testimony. Do we have any witnesses? Chair calls roll. Showsman. All right. Is that close? Thank you for being here. And if you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill, and you may proceed.
Thank you, and good afternoon. My name is Raul Schoenemann. I'm a clinical professor at the University of Texas School of Law. I co-direct the Capital Punishment Clinic. I'm not representing anybody other than myself in testifying on the bill. And I'll be extremely brief. The bill, I think, has already been really well explained by Chairman Moody, and I don't have anything really to add to that. It also really received resounding support from the House in the last session, so I think there's probably not a lot that needs to be said about it. But One in the National Registry of Exonerations studies wrongful convictions, and their data indicates that 1 in 4 wrongful convictions in this case, cases where a person is factually innocent and then subsequently exonerated, rested on false or scientifically invalid evidence at the time of trial. And as Chairman Moody said, this legislature back in 2013 created a post-conviction procedure for review of scientific forensic evidence that was introduced at the trial upon which a conviction is based. In many respects, Texas has really been a leader, I think, in this field with the creation of the Texas Forensic Science Commission, Chapter 64 of the Code of Criminal Procedure, which provides for post-conviction DNA testing, and then Article 11073, which provides for review of junk science and scientifically invalid evidence. This bill, I think, is a really common sense bill that does simply extend post-conviction review of scientifically questionable evidence at trial that was used not simply to establish the charged offense, but another offense upon which punishment may have been based. And so that's what this bill would accomplish. It's obviously enjoyed widespread support of both this committee and this House, and I'm just available to answer any other questions, I guess, as a resource witness for the committee. Thank you.
Members, any questions for the witness?
I do have written testimony here as well. Leave it.
Thank you for your testimony. Is there anyone else here that would like to testify on, for, or against House Bill 205? All right, if not, Chair recognizes Chairman Moody to close on the bill.
I'm happy to answer any other questions, if not close.
Members, any questions for Chairman Moody? Mr. Moody? We did. All right, the committee substitute for House Bill 205 is withdrawn. If there's no objection, House Bill 205 will be left pending. Is there any objection? Chair hears none. House Bill 205 will be left pending. Chairman Moody, would you like to proceed to HB 905?
Yeah, let's move that, if you don't mind.
Go next. Okay. You ready? No. All right, Chairman Moody, would you like to lay out House Bill 905?
Yes, thank you. Members, there's few things as hated in Texas as bureaucracy, but unfortunately it's something we create every day with the work that we do. Sometimes it helps our justice system, but it can also lead to unfair results, and when that happens, it's not just red tape, it's actual people's lives. House Bill 905 addresses a common problem along those lines. Often when a person is held in jail with multiple charges pending, not all warrants are executed and not all holds are placed when they should be. So the person ends up sitting in jail without technically accumulating the time credit they should rightfully be getting. Imagine this: a person commits crime A, then commits crime B, then is picked up on a warrant for crime A later on. In theory, a hold should be placed on them for crime B as well, so that they're getting jail time credit for everything, but that isn't done here because the jail doesn't process the paperwork that they're supposed to. Let's say the person sits in jail for 90 days, then works out a deal with the prosecutor to plead guilty on both cases and receives 90 days sentence. Bizarrely, they've served their time for crime A, but technically have no time credit at all for crime B, even though they've been sitting in jail for 90 actual days after the time at the time the crime was committed. Most judges will simply give the person the time credit for both cases, but some actually won't, and some believe they aren't permitted to by the law. House Bill 905 gives a clear directive that a person is credited for the time they actually serve after a crime is committed, regardless of whether the paperwork was properly processed to place a hold on them. Whatever the person did, when they've served their time, they've served their time. That's how a fair system is supposed to work. And it certainly shouldn't work any other way simply because a clerk or a jailer didn't do what they were supposed to do. Members, that's the simplicity of this bill. I'm happy to answer any questions. If not, I reserve the right to.
Members, any questions for Chairman Moody on House Bill 905? Thank you, sir. We'll proceed to testimony. Chair calls Sarah Jennings. Ms. Jennings, if you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill.
Yes, thank you. My name is Sarah Mae Jennings. I'm testifying on behalf of the Texas Fair Defense Project and myself for House Bill 905.
And what is your position on the bill?
I'm in support of it.
Thank you.
Yes. My name's Sarah Mae Jennings. I'm the Interim Co-Executive Director and Policy Director at the Texas Fair Defense Project, and I'm here to express our strong support for House Bill 905, which is a common sense bill that would help formerly incarcerated Texans get back on their feet and successfully reintegrate into society and the workforce. Over the interim, the Criminal Jurisprudence Committee examined reentry in Texas, exploring recommendations for reducing employment barriers for certain people with a criminal record. This bill is squarely in line with this committee's goals to reduce barriers to reentry and employment for formerly incarcerated Texans. For those facing insurmountable legal debt, giving additional credit for any time served is highly beneficial to their reintegration into society and to the workforce. Last session, legislation was passed to alleviate the financial burden for formerly incarcerated individuals by providing credit for time served against any fines and costs imposed in a case involving a fine-only misdemeanor, so Class C misdemeanors. House Bill 905 builds on those efforts, further alleviating the financial burdens on formerly incarcerated individuals by extending time served credit to any jail time completed during the pendency of the prosecution for all offense levels. Any time spent incarcerated should be given jail credit whenever possible to help formerly incarcerated individuals come out from beneath a mountain of criminal legal debt. At TFDP, we represent hundreds of Texans each year who cannot afford to pay their criminal legal debt. Oftentimes, they aren't able to renew their driver's license due to a failure to pay hold from the Omni-based program and thus are stuck. Unable to get a job until they have a valid license, unable to get a valid license until they clear their legal debt, but unable to pay their debt until they get a job. Sometimes our clients come to us after jail or prison sentences, thinking they've repaid their debt to society. They're frustrated to find that they remain in debt to the legal system, even after spending days, months, or even years in jail or prison. In Class C cases, we're now able to notify the court of incarceration time for higher level offenses and get our clients credit for any time they have served after the ticket was written. But as the law is currently written, the Texas Code of Criminal Procedure 4203 does not allow for jail credit in the same situation for higher level cases. This bill would fix this problem for formerly incarcerated Texans seeking to reenter society and the workforce, and would be an important step for equity in Texas. Thank you.
Members, any questions for Ms. Jennings? Thank you for your testimony.
Thank you.
Is there anyone else here to testify on, for, or against House Bill 905? Not, Chair recognizes Chairman Moody to close on House Bill 905.
Thank you. I just want to apologize for reading off of my phone, but Vice Chairman Cook has my iPad up there, which I usually read off of, and so if my presentation was not top notch as usual, it's probably because of that. Now I'll close at this point.
Any questions for Chair Moody? Yeah, thank you. If there's no objection, House Bill 905 will be left pending. Hearing no objection, House Bill 905 is left pending.
Members, doing our best to work with everybody's schedule. I seeing that we have everybody here now, and I know things can shift. I'm going to vote on some pending matters, and then we have Representative Jatan who has a bill, and Representative Murr who has a bill, and we'll hear those quickly after we vote. substitute? Okay. I'll just double check. Chair lays out as a matter of pending business, House Bill 178 by Mr. Murr, relating to the testing possible controlled substance evidence for fentanyl. We heard this bill last week. No substitute. Okay. The chair moves that House Bill 178 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzwein?
Aye.
9.
There being 9 ayes, 0 nays, the motion prevails. The chair lays out as a matter of pending business, House Bill 188 by Moody relating to certain sentencing procedures in a capital case. We do have a substitute. Chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Members, this is the bill dealing with instructions to jurors in a capital case to clarify the language so it is accurate as to what they're supposed to actually, how they're supposed to conduct themselves. The chair moves that as substituted, House Bill 188 be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison? Aye. Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzwein?
Aye.
9.
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business, House Bill 218 by Moody relating to the criminal and licensing consequences of certain marijuana possession, drug paraphernalia possession, and tetrahydrocannabinol possession offenses imposing a fee. Members, this is the bill we heard last week dealing with leaf and concentrate cannabis penalty reductions. At this time, the chair offers a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Chair moves that, as substituted, House Bill 218 be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Aye. Representative Darby?
Aye.
Representative Harrison? Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzwein?
Being 9 ayes and 0 nays, the motion prevails. We don't have Goldman sub yet.
Not on.
We don't have Goldman sub.
No, we don't.
Chair lays out as a matter of pending business, House Bill 469 by Representative Smith relating to the sequestration of a jury in a criminal case. Members, this is the bill that we heard last week that we saw our former colleague Larry Phillips come and testify on. We all had a great time. The chair thought that would jog everybody's memory. Chair moves that House Bill 469 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Aye. Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzwein?
Being 9 ayes, 0 nays, the motion prevails. Chair lays out as a matter of pending business, House Bill 513 by Representative Metcalf relating to the manufacture or delivery of a controlled substance or marijuana causing the death or serious bodily injury, creating a criminal offense, increasing a criminal penalty. Members, this is a bill that we heard last week relating to prosecution of crimes involving fentanyl. At this point, the chair moves that House Bill 513 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison? Aye. Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. This time, the chair lays out as a matter of pending business, House Bill 598 by Representative Shaheen, relating to the creating the criminal offense of possession of an animal by a person who has previously been convicted of an offense involving animal cruelty.
Is there a committee sub on this?
I don't have one.
Did he was going to put a time limit
Yes.
on it? Does this bill have the time limit or not?
No, my understanding, there was a couple of different concerns that were raised, and Mr. Harrison discussed one with him, and I think you did as well. One including a time limit, and the other, it was...
I was the one dealing with him on a time limit. He's agreed to accept a 5-year.
Oh, that's right. My understanding was that the members had agreed to handle that as a floor amendment. Happy to do it as a substitute. If we'd rather do it that way, though, just let me know. Mr. Leach.
Mr. Chairman, just for the record, I would prefer for us to wait for a committee sub. It's not that I don't trust Representative Shaheen, because I do fully, but I just going forward for precedent's sake, especially while we have time, I would prefer for us to wait for the committee sub and would respectfully request that we do so before voting on it.
That's absolutely fine. And so if there is no objection, House Bill 598 will be left pending. Is there objection? Chair hears none, and House Bill 598 will be left pending at this time. Those are the votes related to bills that we heard last week. And so now, move back to our agenda. Chair lays out House Bill 279, recognizes Representative Jeton to explain the bill.
All right, thank you, Chairman and members. I'm here to lay out House Bill 279, which is related to the prosecution and punishment of offenses of trafficking of persons, amending the penal code to, this bill seeks to add disabled individuals to the human trafficking section as persons receiving additional protections. People with disabilities are at higher risk of trafficking than general population. To prosecute perpetrators of trafficking, law enforcement agencies must usually provide the existence of force, fraud, or coercion to demonstrate trafficking occurred. This is notoriously difficult given the coercive nature of trafficking, but even more so when the victim is an adult with disabilities. House Bill 279 provides additional protections to adults with disabilities by adding them to the category of trafficked individuals for whom force, fraud, and coercion does not need to be proven. The definition of disabled individuals is pulled from the existing definition in code, section 22.021B, as a person older than 13 years of age who by reason of age or physical or mental disease, defect, or injury is substantially unable to protect the person's self from harm or to provide food, shelter, medical care for the person's self. Disability advocate groups have been consulted in drafting of this bill and are in favor of the changes and the definitions used. At this time, I'll pause for questions and reserve the right to close.
Members, do you have any questions for Representative Jeton at this time? No? Wait, we'll reserve the right to close. Is there anyone wishing to testify on, for, or against House Bill 279 at this time? Chair seeing none, recognize Representative Jeton to close on the measure.
All right, well, I'm happy to answer any other further questions. Otherwise, ask for your favorable consideration, and I close.
Thank you, Representative Jeton. Do we have any other questions before we let him go? You can keep him here the rest of the day if you want.
I'm here.
No? All right, no, thank you very much. If there's no objection, House Bill 279 will be left pending. Is there any objection? Chair hears none, and House Bill 279 is left pending at this time. Chair lays out House Bill 291. Yes. By Representative Murr, and recognize Representative Murr to explain the bill.
And Mr. Chairman, I believe there is a committee substitute.
Chair offers up a committee substitute to House Bill 291 and recognizes Representative Murr to explain the bill and the substitute.
Thank you, Mr. Chairman and committee members. House Bill 291 clarifies and simplifies the Occupational Driver License Procedure, or ODL, for the state of Texas and its corresponding statutes, and provides significant benefits to both courts and applicants. In sum, what we have right now is a checkerboard system where the components for ODL are found in different sections of code, and it is left up to both applicants, their attorneys if they choose to have one, and the courts to figure out how all of those fit together. This bill replaces a system of delayed effective dates, which result in either the person being unable to work or perform essential household duties, or the person driving without a valid license and therefore with no insurance coverage, with a system that allows the judge to impose additional conditions. For example, a judge may now restrict a person to an ignition interlock device, where under current law, the ODL may only contain an ignition interlock device, or IID, restriction if the person is already restricted to. Also, the bill makes clear that a judge has authority to order a driving log, which under current law is presumed but not explicit. And so county by county, that requirement can vary. This bill provides a mechanism for courts to modify an ODL order whenever the applicant's driving needs change, such as a new job. This bill provides protection for applicants in situations where DPS cannot turn around an ODL application within 45 days. And I've had personal experience in either representing clients or acting as a judge on the bench where someone doesn't get anything back within the requisite period of time from DPS. Conviction of a violation of the terms of an ODL is supposed to result in a revocation under current law. However, there's no mechanism for ensuring that this occurs, resulting in drivers violating the terms of the ODL and continuing to have a valid license. This bill also creates a mechanism where that conviction is reported to DPS and to the court in which issued the ODL. Currently, the filing fee for an application is found in an AG opinion only. So this bill, as the committee substitute, provides clear guidance to the court regarding the fee. Finally, I will point out that the substitute is the exact bill that was engrossed out of the House after being voted out of Homeland Security 9-0 and off of the local consent calendar, but includes additional clarifying language for judicial discretion. Finally, I'll also add that last session, based on stakeholder input, Section 9 on page 23-24 includes language that ensures that the courts have the ability to lift a renewal hold before a payment or community service plan is being completely fulfilled. And so with that being said, I'm happy to answer any questions, but I do believe I'm bringing to you something that's a better product that both your courts and your constituents will prefer. Thank you.
Thank you, Mr. Murr. Do we have any questions? Nope. Thanks. Reserve your right to close. Chair calls Akanksha Balakai. You can state your name for the record, whom you represent, if someone other than yourself, and then your position on the measure.
One moment, sorry.
Yep.
My name is Akanksha Balakai. I'm representing Texas Appleseed. We're an organization dedicated to changing unjust laws and supporting policies that are data-driven, safe, and efficient. I'm testifying in opposition.
Okay, go ahead and proceed.
So HB 291 expands occupational driver's licensing opportunities for those who've had their licenses suspended, revoked, or canceled. People deserve these second chances, but the eligibility section of this bill precludes those who have been involved in the failure to appear/pay program from those second chances. I want to note that I did not see the committee sub before this, so I can't speak to that at the moment, but I'll proceed anyway.
I just want to make clear, so we do have a couple new members on committee. So substitute came before us. We have it. Public hasn't had a chance to have it. The comments that Ms. Balakai is making are to the bill prior to the substitute. So just take all that into consideration in testimony. So I've seen in my time, people are registered here, they had that language, and lo and behold, the substitute has solved all the issues they had with it. I don't know if that's the case here, but I'm saying, keep that in mind. The substitute is not something that they have access to at this time. But go ahead and proceed with your testimony.
Thank you, Chairman Moody. I appreciate that. So people deserve these second chances, as I was saying, but the eligibility section of this bill precludes those who have been involved in the failure to appear/pay program from those very second chances. The FTAP program effectively suspends someone's driver's license by placing a hold preventing renewal if they are unable to pay off those fines and court fees in full. So HB 291 makes it so that a person who has been convicted of illegal street racing is able to obtain an occupational driver's license, but a person who may not have been able to pay off fines and fees for moving violations cannot. This stipulation doesn't make any sense. The problem here is also the failure to appear/pay program itself, which my colleague Sarah Mae Jennings at TFDP touched on earlier. Driver's license suspensions can cause major financial distress for low-income households, and they only make it harder for someone to get to work so they can pay off their court debt and support their families. This bill is extremely helpful in expanding opportunities for an ODL and subsequently alleviating some of those barriers to employment. But if employment access is a true priority, we should not be restricting the approximately 454,000 Texans impacted by the FTAP program from that opportunity. So we urge you to strike the language that prohibits people in the FTAP program from obtaining an ODL. That will make this a bill that truly accomplishes a lot more of what it sets out to do. We're amidst a labor shortage in Texas. We want and need for people to get back to work. The stipulation in this bill that I've discussed, as well as the FTAP program itself, limits opportunities for Texans across the state. It should not exist, and it certainly should not be used to limit people from even more than it already does. Thank you for your time. I'm happy to answer any questions, and I've shared additional materials as well as my card in case any of you want to reach out with those questions.
No, thank you, and I appreciate you bringing us all that information. Members, do we have questions? I see you mulling it over. Do you have no, you're okay? All right, thank you so much.
Thank you so much. Have a good day.
Chair calls Sarah Mae Jennings.
Hello, Sarah Mae Jennings from the Texas Fair Defense Project, testifying on behalf of the Texas Fair Defense Project and for myself against House Bill 291. Similar to Ms. Balakai, who just spoke before me, I am testifying on House Bill 291 as written. I have not reviewed the committee sub. There is one specific omni-based carve-out that could be very well addressed in a committee sub, but that is the one piece that we're taking issue with here. My name is Sarah Mae Jennings. I'm the interim co-executive director and policy director at the Texas Fair Defense Project. We're a nonprofit organization that fights the criminalization of poverty in Texas. I'm here today to express our opposition to House Bill 291, which is a bill that prejudices the nearly 1 million Texans who are impacted by the omni-based program. In 2019, Texas made history by repealing the Texas Driver Responsibility Program, under which over 1 million people had their licenses suspended for non-payment of government debt. However, many Texans were disappointed to discover that they still could not get their driver's licenses back, most commonly due to a very similar program run by private contractor Omnibase. Under the Omnibase program, nearly 1 million Texans have lost their ability to renew their driver's license until they pay off fines and costs from low-level traffic tickets. The Omnibase program leads to license suspensions, not because people are dangerous drivers, but because they cannot afford their fines and costs. Omnibase holds trapped Texans in a paradoxical cycle of debt. In order to pay off their tickets, individuals must drive to work and/or community service. But if they continue to drive, they risk getting pulled over and receiving more tickets, more fines, and costs and additional suspensions on their driver's license. If they do not continue to drive and are unable to attend court, community service, or get to work to earn income to pay off their tickets, they risk incurring more omni-base holds and warrants for their arrest. Excluding the nearly 1 million Texans who are impacted by the omni-base program from accessing occupational driver's licenses will erect barriers to Texans finding work and getting to work, leading to unemployment and lost wages. Although TFDP does support expanded access to occupational driver's licenses in Texas, we cannot support House Bill 291 as written. Removing Section 521.422 subsection B would cure the issue. Thank you for your consideration.
Thank you very much. Real quick, did you all have the opportunity to visit with Representative Murr's?
I have not had the opportunity to engage in discussion. I apologize. I've reached out to the office a few times. It was a quick turnaround.
Yeah,
I did send
a
red line, so happy to continue the conversation.
Okay, I just want to encourage that.
Yes, thank you.
I know that we're kind of just getting gears moving in session, but I like to always check in and make sure everybody's having those conversations.
Thank you.
Members, do you have any other questions? Yes.
One clarification on your, thank you, sir. In paragraph 3 of your written testimony, it states that the omni-base program leads to license suspension, not because people are dangerous drivers, but because they cannot afford their fines and court costs. But isn't that also, is there usually a failure to appear that's involved there?
It's failure to appear or failure to pay.
Okay, but I mean, just to be fair, when you say it's because they can't afford their fines and court costs, it's also because they're not showing up for court, right?
Possibly.
I mean,
that would be
which
included.
is adding more fines and more court costs because they didn't show up for court.
Mm-hmm.
All right, thank you.
Yes, Representative Harrison.
Thank you, Chairman. Thank you. Just quick, for clarification, you said this at the beginning, I believe, but I think I missed it. You had or had not yet reviewed
The committee staff. I have not seen that.
Thank you very much.
Yes.
I mean, it seems like one of the bigger issues might be, and your organization may have some data to help me with this as a new member to the legislature here. The bigger issue would be that Texans, or at least some good number of Texans, are having their driver's licenses suspended for crimes that have nothing to do with crimes or other things that have nothing to do with their ability to safely drive a vehicle. How ubiquitous is this in the Texas code?
I mean, it is a huge problem, and the bigger issue is not, it's that the omni-base holds are forever. There's no limitation, right? Driving while intoxicated, I think it's a 1-year suspension. Omni-base, once they assess that hold, that is forever on your license until you pay off everything that you owe.
What would be the impact, as you understand it, of this bill, were it to be enacted on very low-income Texans and their eligibility to get an OVL?
This bill, as written, would just create that barrier for the nearly 1 million Texans impacted by the omni-base program. They still wouldn't have access to an occupational license, even though folks who were accused of driving while intoxicated would in other crimes.
Thank you.
Mm-hmm.
Thank you, Chair.
Thank you. Thank you so much.
Thank you.
Chair calls Lynn Holt. Sorry, is it Judge?
Good to see you again, sir.
Yes, sir. Same here, Judge. If you could.
My name is Lynn Holt.
You got it down.
Justice of the Peace for Precinct 4 for Bandera County, and I'm here representing the Justice of the Peace and Constables Association. I've served on their legislative committee for a number of years and worked with Mr. Moody and several of the other legislators to get the legislation passed. Anyway, there's a lot of...
What is it in your position on the bill?
We're for it. Okay. JPCA is supporting it.
Just want to make sure. All right, go ahead.
We as JPs, constitutional county judges, county court at law judges, and district judges all have to deal with this section because they issue ODLs. All the courts do. There seems to be some confusion here. When someone is placed out of JP court into an omni-base, their license is not suspended. DPS just refuses to renew the license until they take care of the fine and court costs. There's been statements made they have to pay it in full. That's not true. Judges have the discretion to put that person on a payment plan, and there's also sections in Chapter 45 where a judge, if they can show that they're innocent, can totally forgive the fine and court costs. So an ODL and an FTA Omni-based program are two separate and totally different things. The reason we've come to here, the repeal last section of the driver responsibility program reportedly caused confusion regarding the state's occupational license program. There have been calls for the state to overhaul and update the state law governing the issuance of occupational license to increase clarity and uniformity in the process and procedure for both citizens and the courts. Representative Murr laid out a lot of the problems that we're having because we do things like require a person to have a log of where they drive every day, what time they leave, how many miles they put on it, and then we require them to turn that in to us once a month, and it's a way that we can monitor their use of the ODL. Right now, if we issue an ODL for an individual to go back and forth to work, if he changes his workplace, we don't have anything in the statute that allows him to come back to the judge to change that ODL. He may even have to apply for a new one. There's a lot of restrictions of where they can apply for that ODL at. I'll just go over some quick examples. If you're convicted in district court of intoxication, manslaughter, intoxication, assault, felony DWI third or more, felony DWI child passenger, then that is required to go back to that court if you want an ODL. If you want an ODL out of a JP court, it's because you refuse to blow an intoxilizer, or you failed the intoxilizer, or you got a citation, say, for no insurance, and DPS suspended your license for a certain date. Then they can come to JP court. Conviction to A and B DWI, they can't come to JP court. They have to go to the convicting court, which is going to be your constitutional county court or your county court of law. So what this does is clarifies what judges can do when they issue an ODL. We have to look at it this way. The state of Texas has told an individual, you can't drive. We're not going to give you a license. This statute allows that person to come to a judge with an application, and that judge has the authority to say, well, yeah, we're going to let you drive. If we're going to be responsible as judges for that person being on the road, he's going to have insurance, and he's going to be legally on the road because we are going to keep tabs on whatever means we possibly can. After all, the goal is when a person gets their license suspended, you know as well as I do what's going to happen. They're going to get back in that car and they're going to drive again. And they're going to get a DWI, and it's going to be a never-ending deal. Mm-hmm. I have a procedure in my court that if someone comes into my court up to the window with a DWI license citation, they have to see me. Why is that? I talk to them about it and ask them why their license is suspended. We have a packet for an ODL. We give them that information packet. We're not telling them to apply for it. We're just giving them the information to be able to get away, for them to be able to drive for occupational reasons, back and forth to work, household duties, higher education, taking care of their children, and medical problems. So we ask you to give this a favorable consideration and clarify everything for us judges and the people who apply for these, because the rewrite is plain language, so the pro se defendant can understand it.
Thank you, Judge. Do you have any questions, members? No? Thank you so much for your time.
Okay.
We'll see you soon. Is there anyone else wishing to testify on, for, or against House Bill 291 at this time? Chair seeing none, recognize Mr. Murr to close on the measure.
Mr. Chairman, members, by my own count, I represent 49 justices of the peace, county judges, or county court at law judges of both parties in 16 counties. And collectively, their organization for the JPs has spoken to you to indicate that this is good legislation. This bill provides benefits that applicants don't currently have. The ability for courts to waive the filing fee, which doesn't currently exist. The refund of a filing fee if someone files in the wrong court accidentally, which doesn't currently exist. And the elimination of delayed effective dates, which currently mean that a successful applicant can't legally drive for up to 1 year after having the application granted. So I'm excited to be able to try to make the process better for both applicants and the court system, make it more uniform across jurisdictions, and at the end of the day, more useful for the end goals. And I think it ends up being good policy. And as I stated earlier, the bill that you have before you with a variation for additional judicial discretion was engrossed out of the House and sent over to the Senate. Unfortunately, that bill had a high bill number. I believe it was in the 3,000s, which means that it started late in the process. Yeah. And, you know, midway through May was referred to Senate committee, and there wasn't enough time to make orange juice. So with that being said, I'm happy to answer any questions you have now or later, and certainly would ask for your favorable consideration.
Oh, thank you. I've been victim of those 3,000 bills, too.
Yes.
Sometimes it takes a special nudge to get those.
It does.
I've been a victim when they're in the hundreds, too. That's like a sign. Doesn't matter. Members, do you have any questions for Mr. Murr? No? All right.
Thank you for your time today.
Thank you. This time, Chair withdraws a substitute to House Bill 291. If there's no objection, House Bill 291 will be left pending. Is there any objection? Chair hears none. House Bill 291 is left pending. Members, there were a couple other items that we posted for. Both of those authors requested us not to hear them today. So you can thank them for the extra time that you have this afternoon, if you want to. I did intend to vote on a couple of measures that we heard today. Based on the testimony, I'm just going to pen that until the next time we get together. So, let's see. Members, that does conclude today's agenda. The time is now, is there any further business for the committee to address? If not, Chair moves to adjourn. Is there any objection? Hearing none, the committee stands adjourned at 3:03 p.m. Subject to call of the chair.